Good afternoon. The hearing session is now open. It forms part of the examination of the Waverley Local Plan Part 2. My name is G.J. Fort and I'm the inspector appointed by the Secretary of State to conduct the examination and to report to the Council in due course. As ever, the format of the hearing is a structured and focused discussion that I shall lead. So before we continue any further, could I ask for the Council representatives to introduce themselves, please?
So yes, good afternoon, Wayne Beglan of Council for Waverley Borough Council. And so I've got a slightly longer cast list for the purposes of today. I have with me Mr. Longley, Miss Dove, behind me Mr. Ellis and Mrs. Nash, and then on Zoom we should have Mr. McEntee and Mr. McLeod and also Dr. Riley.
Thank you. And other participants in the room, please.
Good afternoon, sir. Jesse Chapman of D&M Planning.
Good afternoon, sir. Graham Ritchie of Wolf Bond for Antler Homes.
Good afternoon, sir. Mark Busey, DHA Planning on behalf of Bellway Homes.
Good afternoon, sir. Mark Barrett from the Home Builders Federation.
Good afternoon, sir. David Neame from Neame Sutton here today on behalf of Bewley Homes PLC, Reside Developments, Monkhill Limited, Redwood Southwest Limited, Crown Hall Estates and Castle Properties.
Good afternoon, sir. Estelle de Hon QC here on behalf of Ashill Land.
Good afternoon, sir. Christopher Roberts, Boyer Planning on behalf of Ashill Land as well.
And those joining us on the Zoom feed, please, starting with Mr. Munton.
Good afternoon, Andrew Munton from Reside Developments.
Mr. Banner.
Good afternoon, sir. Let's get my camera to work. Charlie Banner here on behalf of Monkhill Limited.
Mr. Vesey.
Dominic Beasy here on behalf of King Acre Estates and I'm from Nexus Planning.
Mr. Wood.
Yeah, good afternoon, sir. Michael Wood, WSP on behalf of Plumgun Land.
Mr. Mools. You're muted, Mr. Mules.
Good afternoon, sir. Richard Moles on behalf of Waits Development Limited. And just to say that Judith Ashton will also be appearing for Waits. She's stuck in very slow moving traffic, but hopes to arrive in the next 10 or 15 minutes. Apologies for that.
Thank you. And Mr. House.
Good afternoon, sir. Tim House here on our own behalf.
Thank you. So the programme officer for the examination is Charlotte Glancy, who should be the main point of contact prior to and after the hearing sessions and should be copied into all correspondence. I'll now pass over to Charlotte for our usual housekeeping notes.
Good afternoon, everyone. This is just the fire notice. In the unlikely event of a fire or other serious incident, the alarm in this building is a siren. If the alarms are inoperative or inadvisable, in a bomb emergency, the instructions to leave will be given by word of mouth. If the alarm sounds, leave by the nearest safe fire exit. Please note the position of fire exits from the room. Do not stop to reclaim personal effects. Do not use the lift and proceed to the assembly point, which is located at the far end of the Berries playing field opposite the council offices during the daytime until 6:30 in the evening. And then after 6:30 in the evening, it's Waitrose car park. And remain at the evacuation point until instructed that it is safe to re-enter the building. And the toilets are through the corridor, turn right, and then they're on the right-hand side. Many thanks.
Thank you. A reminder to switch off or turn to silent any mobile phones that you might have. The hearings are being filmed and live streamed. I take it everyone here present is comfortable with that. The matters to be discussed today will be focused questions based upon and taking forward the matters, issues and questions and the associated written statements received. I am tasked with considering the soundness of the plan in accordance with the criteria of the National Planning Policy Framework and also whether it is legally compliant. The hearings are intended to assist me in that regard. In submitting the plan, the Council considers that it is a sound one, and this is the starting point for the examination. So if you're challenging the soundness of the plan, then you have to explain why and what changes might be necessary that will make it sound. I have read and will take into account all the hearing statements that have been prepared and the original representations that were made, so there is no need for these to be substantially repeated. Instead, the aim is that the discussion today moves on from those documents and deals with specific questions I have or areas where further clarification or explanation are required. At times, I may ask for a more general contribution or a summary of your position. In order to test the plan for soundness and legal compliance, I will have to ask questions. You have seen I've already been doing this both in preliminary correspondence with the Council, in the published matters, issues and questions document, and in earlier hearing sessions. And both the Council and other participants have had the opportunity to respond to these. The questions will continue today. However, anything that is asked should not be taken as demonstrating a particular predisposition on my part. I will normally start a particular topic by asking the Council for responses to questions I have before indicating that I wish others to comment. For those of you in the room, if you wish to comment, if you could please indicate this by turning your nameplate on its side. If you are joining us via Zoom, if you could use the hands up tool. I may invite contributions from participants on specific points where I think that that may assist the examination. In the course of discussion, if you wish to highlight certain parts of your statements or other documents that form part of the examination, then it will be helpful to me if you can provide the references. Those joining us on Zoom will have to make sure they are unmuted when speaking to me, but muted at all other times. And those in the room should use microphones when speaking to me. If any of those joining us on Zoom experience technical difficulties, they should make contact with the programme officer in the first instance. It is open to the Council to propose further changes to the plan, and I would ask that they keep a record of possible changes that arise during the discussions. Any changes that will constitute main modifications will be subject to future consultation. So are there any questions at this stage about the procedural side of the hearings? Okay, so if we can move on now to the substantive discussion for this afternoon. So we'll return and resume our discussion on the general housing requirement and supply aspects of the plan, which we started last week. So at the outset, I'd like to point out that I'm well aware of the different positions of parties in respect of the scope of the plan. So these aspects do not have to be substantially repeated in this session. Last week, we heard Mr. Neam's assessment of supply over the plan period, which was also included in hearing statements. And in response to this and evidence submitted by others on this matter, the Council has, at my request, produced an assessment that has been uploaded to the examination library and circulated, and hopefully participants have had an opportunity to familiarise themselves with this material. So in opening this session, I invite the Council to outline the rationale for the material that's recently been produced, highlighting in particular where the evidence provided leads to its conclusions in terms of deliverability and developability of sites against the definitions given in the glossary of the National Planning Policy Framework.
Thank you, sir. The information that we submitted to you earlier this week comprised a housing trajectory setting out the different components of the supply over the remaining years of the plan period, together with details of the housing completions up to the 1st of April this year, and the list of outstanding planning permissions covering the same period, so the 1st of April this year. We also submitted a table that set out the number of completions and outstanding permissions broken down by parish. So it's sort of comparable to the information that already exists in local plan part 1 and gives perhaps an updated picture on the situation. The council's view is that the information will help in terms of being able to show the position in terms of housing land supply for the remaining years of the plan period, and within the housing trajectory it includes the different components of supply similar to those that are included at Appendix C of local plan part 1. The sites which are completions we think should obviously be included together with outstanding planning permissions, and because they're determined as deliverable against the MPPF definition where they've got a full planning consent. We've also included sites including the draft site allocations for local plan part 2 within that will be delivered within the remaining years of the plan period, Dunsfold aerodrome, LAR sites, and also Windfalls as well. And I think an explanation of our approach to Windfalls is included in our response to the MIQ matters. The council considers that it's taken a reasonable approach in terms of preparing the housing trajectory and the sites included within it, and therefore I think that it should be sort of included within local plan part 2.
So we touched on this last week, and I'm aware of your view and those of Inspector Bohr in the report on the Part 1 plan, particularly footnote 15 on the distinction between plan examinations and appeals on this matter. But the recent appeal decision relating to Reg Court, you'll be well aware of the inspector's conclusions in terms of the deliverability of some of the sites. In that decision letter. So what's materially changed in headline terms since Inspector Hockenhull came to those conclusions, and what is before us now?
Well, so part of the exercise that the local authority has done in the background is actually to look at the list of sites that was considered by Inspector Hockenhull. And we've been through that list, and Ms. Dove can give more details in relation to the individual sites. But two features have changed across the range of sites that were under consideration then, as well as what I would say is the third difference, which is the lens you look through at the local plan stage, which is different for the reasons that Inspector Bohr explained, and that I'll carry through in the PPG. And so I've got the reference for that if it helps, but I'm sure you're familiar with it. So the two main changes are that circumstances have moved on in relation to a number of those sites, sometimes in particularly significant ways, sometimes in smaller ways, but in most cases there have been changes of circumstance, but also there has been a change in the way the sites have been treated. So in relation to a number of the sites, they're no longer now put within the deliverable part of the plan, but they're looked at as being developable sites, which will come forward within the plan period. And so, sir, if you want to go through those sites individually, it's useful perhaps to use Inspector Hockenhull's decision as it were, the anchor for this, because I think she looked at more sites numerically than the other two inspectors did, and of course came to a conclusion that on the development management side we have 4.25 years, as at that point in time. But so we can certainly do that exercise if it would assist you, and perhaps I'll hand over to Ms. Dove to take you through the details.
Yes, that'd be useful. Thank you.
So in terms of, if I take it site by site, in terms of the sites that have been discussed, there was land at Centrum Business Park at Farnham. And we'd included the site at the time within the 5-year housing land supply position statement. This was the one that was published in 2021. We've since reviewed the situation and obviously the appeal decisions that have come out. And the council is now on the view that it's unlikely to be delivered within the next 5 years. So in terms of the position statement that the council will be publishing to the 2022, it's not been published yet. It's not proposed that that site will be included. We then have land at Oxford Water. There's a current planning application on the site. It's still pending. At the time of the appeal, we had an issue about ecology and there being outstanding issues about great-crested newts. That issue has now been overcome and resolved. And the only thing that's now outstanding is about an affordable housing element, about reassessing the viability assessment for that. But work is progressing on that, as I understand it. So there has been progress in terms of that site since the appeal. We then go on to land at Barons of Hindhead, which I think has probably been discussed in earlier sessions as a draft local plan part 2 site allocation. There's an application pending on the site that was submitted in 2021 for 38 dwellings on the site. You will obviously know that the former use of a garage has already been relocated, and we just, as a council, don't think there's anything to significant that would sort of prevent development taking place on that site at the moment. Then we get on to land to the rear of 101, the High Street in Cranley. Since the planning appeal, there's been a planning application submitted for 38 retirement units. That application is pending at the moment. It's not in the 5-year supply under the trajectory. We've put it in later in the plan period, but we still think that it's deliverable by 2032. Then we go on to land at Weyhill and Hazelmere. There's obviously been progress on the site in terms of relocation of the community groups that formerly occupied the site, and the council started to liaise with commercial leaseholders on that site. And those leases, I understand, are short leases. It is included in the 5-year supply under the trajectory for units coming forward in sort of 25, 26 and 26, 27. In terms of the Woolmead in Farnham, it benefits from full planning permission, and therefore we consider it to be deliverable under the definition of the MPPF. In terms of 34 Kings Road in Hazelmere, there's no evidence that we're aware of to demonstrate that the 5-unit scheme is unviable. The site's been for sale, and sales particulars have referred to both permissions. And obviously, given the character of the surrounding area, there has been quite a few sites where they perhaps demolished the existing building and rebuilt it to provide a more densely developed scheme. We've included it in the housing trajectory for sort of 11 within the sort of the 5-year supplies. It sort of benefits from a full planning permission and therefore deliverable under the definition in the MPPF. We then go on to Salisbury House in Wayside Park in Godalming. That's now got a full consent for 6 flats on the 3rd floor, and it's got a prior approval for conversion of the former office into C3 residential uses to provide 23 dwellings, and that site is included within the first 5 years under the housing trajectory. In terms of land at Waverley's Folly and Badshot Lee, the site now has a reserve matters approval on it that was granted on the 3rd of May this year for 23 dwellings. Therefore, it's included in the first 5 years of the trajectory, as it benefits from being deliverable under the MPPF definition. In terms of Coxbridge Farm in Farnham, the site has a resolution, now got a resolution to grant outline planning permission. That was the planning committee resolved to grant that at their meeting on the 18th of May. It's subject to signing of a Section 106 agreement. I understand that progress is being made on signing that Section 106 agreement. It is included within the housing trajectory that we've provided. We're anticipating 60 units being delivered in the first five-year period, with those 60 units being towards the end of the 5-year period, and then the remainder of the dwellings being delivered over the remainder of the plan period. Then in terms of the Meadow Nursery West and Meadow Nursery East sites, again, we've included the site within the housing trajectory, but not within the first 5 years of the plan period. We're proposing that units will probably be delivered later on in the plan period to reflect the fact that although it's got two current planning applications on the site, which are both pending, we're just not quite sure whether or not it will come forward in the first 5 years, so we put it in later. Southview and Chiddingfold, it's included within the housing trajectory for 8 units for sort of 2027 to 2028, so it's not within the first 5 years of the plan period. Land at Wildwood Close and Queensmead.
Sorry, in terms of Meadow Nurseries, so what yield was anticipated?
We've anticipated that as, sorry, bear with me. $19. Then we go on to land at Wildwood Close and Queensmead and Chiddingfold. Again, we've not included that within the first 5 years, but we have included it within the housing trajectory. We're looking at sort of 10 units within the years 27, 28, 25 for years 28 to 29, and a further 25 units in 29 to 30. Then in terms of Andrews at Hindhead, we have included this within the first 5 years of the plan period, since it's now got a full planning permission, which was granted on the resolution to grant on the 30th of March this year, and the decision notice was then issued on the 4th of April. So the site's included for 39 units. That was a C2 use, the permission, so we've converted it into 39 C3 units using the formulae within the housing delivery test measurement rule book. We then go on to the Old Grove in Hindhead. That has a current outline planning application for up to 18 dwellings. It's currently pending, it's not being determined yet, but we have included that within the 5 year, within the housing trajectory, within the first 5 years of the plan period, with 8 units in 25-26 and 10 units in 26-27. Were there any other sites that I've missed off? Sorry, sir.
Milford Golf Course.
Milford Golf Course, okay. We have, in terms of Milford Golf Course, it's now got a full planning permission. Reserve matters was approved on the site. We have included it within the housing trajectory, but not within the first 5 years of the plan period. Obviously, we're aware of the restrictive covenant that affects the site, but instead we've put it down as being deliverable within the latter part of the plan period from 27-28 through to the final year of the plan period.
Mr. Begum.
So I just wanted to check with Just have one point of detail, which may have been mentioned, but in relation to land at Barons of Hindhead, I think I'm right in saying that for the purposes of the trajectory, that's also been moved to outside the first 5 years.
Yes, it has. Yes.
So perhaps that gives a flavour of how things have moved on, we would say, since January, February of this year, and also the way that the local authority has reacted to some of the observations that have been made by your colleagues in those decision letters.
Okay, and in terms of the Dunsfold aerodrome allocation, so we've got the material that's been provided by Bidwell. Is there any highlights you want to draw to my attention on that?
Of course. So the site, Dunsfold Aerodrome, is included within the housing trajectory. We have, as you've mentioned, received up-to-date information from the landowners for Dunsfold Aerodrome about the anticipated trajectory in terms of delivery of housing on the site. The council's reviewed that and considered that it is acceptable and appropriate. So we have included the site within the housing trajectory for 1,905 dwellings. Obviously, that is lower than the number included within the local plan part 1 housing trajectory, where it was included for 2,600 dwellings. We've included a sort of a buffer at the beginning of the 5-year period, so we're not anticipating completions to start until 24-25 to enable time for the landowners to and house builders to secure the reserve matters application and permissions. As I'm sure you're aware, there's been quite a lot of work undertaken on the Dunsfold site in terms of preparing it and getting it ready for development to commence on it. So it has, in terms of the enabling works, there's been a planning permission granted for a link road onto to gain access from the main road onto the site, and a roundabout as well. It's 2 separate planning applications. They've been granted and work is due to start fairly shortly on that. I'm just think in terms of the note that we received from Bidwell's, they've actually set out the work that they're proposing to do that. So they've so during this year, they're wanting to sort of discharge the conditions in terms of archaeology to support the delivery of the access road, and also looking at discharging the conditions for the roundabout as well. They're wanting to undertake the sort of ground conditions enabling works attached to the hybrid consent, and also it's really so that developers can come on board and it's, I hate using the term, but sort of almost oven ready, so that they've got service plots ready for the developers. A little bit later on down the note from Bidwell's, they're also saying about they're wanting to look at submitting details for the master plan and phasing plan attached to the outline and hybrid consent by the end of this year, in order so that they're ready for when the first reserve matters approval is submitted, and also looking to submit a reserve matters application linked to some of the infrastructure required to support the first reserve matters for the residential element as well. It's clear to us that there is a lot of work being undertaken on Dunsfold, and in addition to this, the council's also adopted the Dunsfold Park SPD, which was adopted in February this year, to help guide the development of the site, so that house builders and developers can see, I suppose, what the council sort of envisages for the site, and to help support them in terms of their forthcoming planning applications.
Okay. I think we'll come on to assumptions on windfalls more generally further down the discussion, but there's a distinction in the trajectory between windfall sites, other deliverable sites, and LAA sites in general. So how is that distinction drawn, particularly in terms of other deliverable sites? Does that relate to a sort of tangible assessment of sites?
Yes, so the sites that are included under the other deliverable sites category within the housing trajectory are those that have been granted planning permission since the base date of the 1st of April this year. So we have included those because they now benefit from meeting the definition of deliverable. So those sites are included under that category. We've also included within that category land to the rear of 101 the High Street in Cranley, that although that doesn't benefit from a planning consent yet, as I mentioned earlier, it is a brownfield site in an urban location, and the council's not aware that there are any constraints to development coming forward on that site in due course. So we haven't included it within the first 5 years, as I said, but it is included within the housing trajectory to come forward perhaps a little bit later in the plan period. We've also included a site called Chasemore in Portsmouth Road in Hindhead for 10 dwellings. Again, that's in a similar situation. It hasn't got planning permission, but it's considered to be sort of a suitable site for development to come forward later in the plan period. So it's not within the first 5 years of that. In terms of the LAA sites, those sites are those that are included within the land availability assessment that was produced in 2020 and update in 2021. And it's those sites which are identified as green, so they're considered to be suitable, but they're not draft allocations within local plan part 1 not allocations in local plan part 1 or draft allocations in local plan part 2, and equally are not draft or allocations within neighbourhood plans either. So there's not many sites that sort of fall under that category.
So turning to there's two different approaches. There's the Sedgefield and Liverpool method in terms of determining the supply. And two different analyses have been provided. Now, given that in LPP 1, the inspector was clear that the Sedgefield method should be used, is there any particular reason for these different versions?
So there is a particular reason, but it starts, and having heard what you said at the start of this session, I won't rehash anything that we dealt with comprehensively last time we were dealing with matter 6 issues, but you know that our starting position is dealing with the daughter document. There's no obligation for you to test a requirement of 5-year housing land supply in any event. So that's where we start from. And bearing that in mind, what we say about the inclusion of the Liverpool test at this stage, bearing in mind what Inspector Ball said when LPP 1 was under consideration, is that circumstances have changed. And the way that they've changed in almost precisely mirrors what happened, for example, at Mid-Sussex. So when you go back to the Mid-Sussex Inspector's report, what you'll see is that the reason why the Liverpool approach commended itself there was due to strategic sites coming later in the process and the prospect of the site allocations document being delayed potentially by a longer period than Inspector Ball anticipated would happen here. So whilst one can understand very easily why Inspector Ball was keen that the normal approach of Sedgefield should be adopted when LPP1 was going through. In fact, when you look at the facts of what has happened since, objectively, what has happened actually puts us in very much the category that Mid Sussex was in when the decision making went the other way in relation to Liverpool for the reasons that were explained in that report. There's also a clear similarity in what happened in Guildford as well in relation again to the strategic sites coming later on in the day. And you will know that that is really the central plank of the PPG guidance as to when it may be appropriate to use the Liverpool method. So that's the thinking behind advancing the Liverpool method as an alternative for you to consider at this stage. And we do it firstly on the basis that it would be a legitimate way to approach 5-year housing land supply now for those reasons. But we also put it forward on the basis that it's a useful sensitivity test as well. Because one of the things that we did discuss when we were looking at Matter 6 last time was the council's position that it considers it can demonstrate 5 years worth of housing land supply. Others say no. And so depending on the judgments that you make, the issue may arise for determination. Well, if I've decided for myself that I do have to at least consider whether or not the 5-year housing land supply requirement can be met within LPP2, how should I go about that exercise? And part of what we were suggesting to you on the last occasion, again, without rehearsing the full argument, was that there are a number of material considerations here that even if you were to reach the conclusion that there is a level of deficit, nevertheless militate towards pushing this plan forward so that the very clear benefits that we say it provides can be brought to fruition. And as I say, unless it assists, I'm not proposing to rehearse those again, but that's part of the argument. And so what that feeds into is the idea that it's useful to have a sensitivity test. Because if you form the view that in relation to 5-year housing land supply, we're there or thereabouts, then you might place more weight on those other factors and benefits. And you might, for example, conclude that this is one of those cases where the PPG, which articulates the idea that if there is a deficit, wherever possible, there should be further allocations. You might think that in all the circumstances, we come within the exception to that rule. Or you might think, as it would be perfectly within your judgment to decide, that in fact there are sufficient other material considerations here, and looking at the thrust of national guidance as a whole, that in fact we ought to again be getting ourselves over the line and bringing to fruition the benefits that we say arise. So that's really why the Liverpool test is in there. It serves at least two functions, which we say are useful for the purposes of your analysis of soundness. So I'll just check whether anyone wants to add anything on that. No, thank you.
Mr. Neame.
Thank you, sir. If it's okay with you, I've got quite a bit that I want to run through from what I've heard. Can I deal with it in reverse order and start with the points that Mr. Beglin's just raised about the Liverpool method and then come on to the sites? I have to say, and I don't mean any disrespect to Mr. Beglin, but I find it quite outrageous that the council are even suggesting the Liverpool method. Outrageous from the point of view of those people that actually need homes in Waverley, sir. And forgive me, I will just make one contextual point that I didn't make last time. The March 2022 affordability ratio data for all authorities across the country puts Waverley at 18.32 times the average salary. The most expensive place to live in the country outside of London. The average is 8.93 across the country, sir, so you've got the benchmark. So that's taken from the affordability ratio data published in March of this year. The need for homes now in this in this borough is unquestionable. To suggest that a backlog is therefore dealt with via the Liverpool method, I think is completely outrageous. If I can then come on to the more objective points, if you like, and we have a clear position here that actually the planning authority willingly signed up to the Sedgefield method. You'll see the reference that you've been referred to, I think, already by Mr. Beglin in your colleague Inspector Ball's report. It was actually a statement of common ground between myself as chairman of the Waverley Housing Forum and the council at the time, where the Sedgefield method was applied. The Sedgefield method was applied in the context of a uniform housing requirement, so no step trajectory, and also in the context of, I think, a 5% buffer at the time and not a 20% buffer. I raise those points, sir, because that at least in part differentiates Waverley from Guildford Borough. Yes, the Liverpool method was applied in Guildford Borough in the context of a 20% buffer, and in the context of a very different arrangement in terms of plan delivery and strategic sites, infrastructure delivery in particular in Guildford, outside of the control of the planning authority, namely with national highways in terms of junction improvements to the M25 and A3, to name just one example. So Guildford is a bad example in terms of why Liverpool should be considered. So we have a position where the council accept the Sedgefield method. The PPG directs us to the Sedgefield method. We also need to bear in mind that in February of next year, because of the absence of any review of the Part 1 plan, too many methods here, the standard method will take effect. And of course, when the standard method takes effect, the debate over Sedgefield or Liverpool is irrelevant. So I really would very strongly urge you in any assessment you may make, or may choose not to make an assessment, but in any assessment you may choose to make about the method, that the Sedgefield method is very firmly the correct approach, the approach the council willingly endorsed at the local plan Part 1 stage. If I can come on to then the various issues in terms of supply. Now, what I'm not going to do, sir, if it's okay with you, is I'm not going to go through those sites one by one in the appeal decision. It was an appeal that I presented the land supply evidence in, so I know the position on those very well. But what I wanted to do was to just take you through a number of key examples to illustrate the points I wish to make in relation to the council's latest trajectory data. I have supplied you with 2 updates to my trajectories. I'm not sure whether they have been accepted and therefore whether you've seen them, sir. If you haven't, I will do my best to explain on the basis of the paperwork you do have in front of you. There are a number of points I think I just want to draw on in terms of miscalculation from what I can see, and I'm grateful if the council wish to clarify this for us all. So the total figure for large site completions in the update to the Appendix C table is different to the total figure in the schedule of large site consents that the council have supplied, namely the evidence that underpins that row of supply. The key difference between the two appears to be that Milford Golf Course is not within the detailed site schedule, i.e. it's been removed altogether. But the numbers associated with Milford Golf Course appear to be in the Appendix C schedule. So that's the first one. The second one then, say you have a detailed table in terms of the delivery trajectory for the LPP2 allocations. The total in that table differs from the total in the Appendix C line entry for the same supply source. I can't reconcile that one, sir, but that's a question perhaps the council can answer. If we then come on to the supply sources, and I think the key one I just want to spend some time on, sir, is Dunsfold, because actually I think that illustrates the point without needing to visit any other sites, quite frankly. So the evidence that you've been asked to consider has been set in the context of that footnote 15 from Inspector Ball, namely that we need to take a wider view, and that's exactly the approach that my trajectory work seeks to do in terms of differing from a detailed site-specific 5-year supply assessment. And the council say that they have up-to-date evidence, and the up-to-date evidence that they provided to you is a note from Bidwell's dated July 2020 and a note from Dunsfold Airport Limited dated July 2022. So 2 notes. And yes, I did dwell on the dates because I am unsure whether that's a typographical error or whether it is in fact a 2-year-old note. The council have sought to bring forward, sir, delivery on that particular site from the position that was established, as you quite rightly raised, by one of your colleagues, but actually 2 others as well. And in actual fact, one of the other appeal inspectors actually pushed the delivery further back still. And you're being invited to consider the evidence as having changed the position. So I think we just need to see what the evidence says, but also what the position is. So Bidwells are the planning agent acting for the promoter. The promoter is Dunsfold Airport Limited. They are not the owner of the site. The site is owned by Trinity College, Cambridge. You'll be aware, sir, from having read the Section 78 decisions, that actually the site is currently on the market. Trinity are looking to dispose of their freehold interest. There is a preferred bidder, Columbia Threadneedle. Columbia Threadneedle are in discussions to complete, and I'm advised by Savills, who I'm working with on a number of sites. Savills are actually the agent appointed jointly with Bidwells to sell the site. That purchase is due to complete in Q4 of this year. Now, that is particularly material to your consideration of the council's evidence on when this site will deliver, but more critically, for the purposes of the plan, how much it will deliver during the plan period, as opposed to whether it's a 5-year housing land supply delivery site or not. And so that throws then into extreme question the 2 notes that you have, because what are they actually based on? There is no developer currently. There's no house builder signed up currently. The landowner has not given you any evidence, or the council. The prospective purchaser has not presented any evidence. And so all of this is exactly the same as the position that was presented to your 3 colleagues. And so you can see that actually in paragraph 71 of Inspector Hockenholz's report, where she goes through those exact points. And you'll see, sir, that she also deals with the points that Ms. Dove brought to your attention in terms of the consents that exist for the roundabout, the consents that exist for the access road, all of which nothing has changed since that point in time. And also, in fact, the anticipated commencement on site in 2022, exactly the same as the position conveyed to you now. As was the fact that we have no firm start date provided to this examination, no firm start date was provided to that inquiry. So there is significant uncertainty over when that site will actually commence and who will commence it. But one thing is certain here, sir, that bringing the delivery forward from the position established only a few months ago on the basis of the evidence that the council have given you is just simply an untenable position. There are, of course, other issues that we need to consider, sir. For example, as Ms. Dove highlighted, the council have adopted a detailed and very detailed SPD. That SPD actually makes reference to the potential need for a fresh planning application, a fresh consent, certainly a new master plan. If a new consent is required, which is entirely reasonable if there is a new landowner bringing forward new development partners, there will be a need for a new environmental impact assessment, all of the attendant work that goes with that. And that's before we get to a position where we have an implementable permission for residential dwellings, which we don't currently. So to suggest that there will be delivery coming forward from that site in the next couple of years is just simply unrealistic, sir. And as I say, all of that was before your colleagues in those three cases. I picked on Inspector Hockenhole in particular because that's one I'm very familiar with. Nothing has changed materially since that point in time. Sir, I will also just flag a couple of other points in relation to that site. So again, before your colleagues as well, the council has in fact extended the temporary permissions that exist on the site until April 2024 for motorsport and filming of certain TV programme that people may be familiar with. Those uses, although the council argue that those uses can continue to take place, there's an obvious compatibility issue in terms of noise and the acceptability of residential dwellings. The council may suggest to you that there's a temporary solution there, but my view would be that it's very unlikely that a house builder would look to produce houses with a temporary noise attenuation solution next to a racetrack. It's simply not desirable. So in my submission, sir, the only credible evidence you have on delivery is the evidence that I and other colleagues, particularly Ms Ashton, Mr Berrett for the HBF have relied on, which is the Lichfield's evidence on delivery rates, sir. And those delivery rates are significantly below the annual delivery rates you're being asked to adopt by the council here. And actually, sir, if the mathematics are undertaken particularly on the Bidwell's note, what Bidwell say will be delivered in terms of 68 dwellings per annum per outlet does not add up to 260 dwellings per annum when 3 outlets are in operation, which is what they suggest will take place. And just one final point, which I know others around the room will talk to in more detail than I, so I'm not going to go into detail, but you'll be aware, sir, that there is also a very recently granted Secretary of State consent for UK oil and gas exploration to take place underneath the Garden Village site. I know others will want to address you on various detailed matters associated with that. But so all of that leads me to the position that the trajectory that I've set out for you in terms of Dunsfold, which I haven't changed in my latest information submitted to you, it is reflective of that position. It's reflective of the position that your colleagues in the various Section 78 decisions have accepted. And it is consequently significantly lower than the council suggest the site will deliver. So, sir, as you'll see, I have a total figure of 790 dwellings across the plan period. That the council have just suggested to you that that would actually be 1,905 dwellings. And sir, obviously you're aware that the existing outline consent is only for 1,800 dwellings, so that there isn't actually a consent at all for 1,905 dwellings on the site. The consequence of just that one change, sir, and whether you adopt my figure or there are slight adjustments to that in terms of Ms Ashton's figure. I know that Mr Berrett's perhaps been a bit kinder to the planning authority in his figures, but actually across the board, that gets to a position where the plan fails to meet the minimum local plan part 1 requirement, and crucially in relation to the 5-year housing land supply debate, the plan fails and continues to fail to deliver a rolling 5-year housing land supply. And so that's before we get to consider any of the other issues in terms of site delivery that you've rehearsed in your questions actually this morning. I would simply just, and I will keep it short, sir, because I realise I've had the mic for a very long time now, but that there are a number of supply sources the planning authority are relying on, which, based on the evidence that we've been supplied with thus far, do not meet that Annex 2 test in terms of either being deliverable for the purposes of including them within the current 5-year period, or developable for the purposes of including them within the period beyond. And I think the key point in that definition of deliverable is that the planning authority has to show that they will be available and could be viably developed at the point envisaged. Viably developed. We have no evidence, sir, put simply. Those supply sources, sir, in headline terms are the resolutions to permit that are included within the 5-year supply in terms of deliverability, the other deliverable sites in terms of developability, because up until about 20 minutes ago, we weren't actually aware of what those sites comprised, and we're still not aware of exactly which sites the council are relying on in that supply source. And then also the emerging neighbourhood development plan allocations. So the impact of all of this, and I'll come back to windfalls as you've suggested, but I'll give you the headline position now, which is inclusive of my position on windfalls. But the impact is that if the adjustment is made to Dunsfold alone and accepting all of the council's new evidence, there is a shortfall of 1,000 dwellings between now and the end of the plan period. If the adjustments are made to reflect the Annex 2 definition correctly, there is a shortfall of 1,600 dwellings as a round figure between now and the end of the plan period. So that is a soundness failing that needs to be rectified by this plan. It's a failing that can be rectified by this plan through modification. It's not a terminal failing in my view. I think those are all the points I wanted to raise at the minute. I'm conscious that everybody else is going to want to speak. And if I may, I'll come back to windfalls. Thank you.
Thank you. Mr. Banner.
Thank you, sir. Can I just check you can hear me, first of all?
Yes, loud and clear, Mr. Banner.
Good stuff, that's good. Firstly, I adopt what Mr. Neem has said. I want to respond principally to what the council said about the in their view, the plan-making context being different so as to enable and justify the conclusion that despite the line of appeal decisions saying there isn't a 5-year supply, the position is different here. And so the first point I wanted to say by way of context is, of course, you've heard the other day and repeated a few moments ago, Mr. Beglan, so the council's position is that there isn't a requirement for this plan to secure a 5-year supply, and that's the basis on which it's been prepared. And yet with the same breath, it said, well, but in the context of this plan, unlike the various decisions, you can identify a 5-year supply. And that's tantamount to them saying that they've through this plan, they've secured a 5-year supply, not deliberately, but by accident. And I'd suggest that that lacks credibility in the context of the long line of decisions. The second point, so, is that it was suggested to you that the test in relation to 5-year supply is different in the plan-making context compared to the decision-taking context. That's not right. It's not what Jonathan Ball said in paragraph 50, in 53 to 55 of his decision letter. 53 talks about the PPG recognising that Section 78 appeals can't consider the whole plan-making picture. The point made there and reiterated in the PPG in paragraph 6810 is that typically it's the case that in the plan-making context, there's a wider and deeper evidence base. It's not that the test is different. The test remains the definition of deliverability for identified sites and the compelling evidence test in relation to windfalls. That is always the test. The point is simply that at the local plan stage, you often have a better evidence base. Now, the difficulty with that argument here is you don't have a better evidence base because the council's evidence base is conspicuously lacking in relation to 5-year supply. Perhaps a consequence of the fact that it till recently has proceeded on the basis we didn't need to show one. And we can test, firstly with Mr. Dean's point, but secondly, we tested this way. That in relation to leaving Dunsfold aside, in relation to outline permissions, category B sites and allocations, all you have in the trajectory is the table, is the unreasoned tabulation approach. Now, that is the very approach that, for example, in the Longdean case, the second Longdean case, the John Walcott case, that unreasoned tabulation approach of 5-year supply was rejected by Jean Roux. That was why he took out the category B sites in that case, because it doesn't amount to clear evidence. The completions will begin within 5 years. There's simply no basis to say that the evidence base set out, I think it was 2 days ago by the council, either viewed on its own or in conjunction with their hearing statements, is a better evidence base than that before the succession of expectors. And there's also an associated point, of course, which is that what Mr. Board noted was that there'd been a change of service. There's been a small number of appeal decisions, as his words, of 53, a small number of decisions can calculate a 5-year supply based on 20% buffer and band. It wasn't supply. Of course, what we now have is a large number of decisions. I mean, you've seen the table, which I've mentioned a number of times. I think it's 16 decisions, all of which found there wasn't a 5-year supply, and all but one of which found the council had overstated the position considerably. This isn't now a small number of decisions. If anything, the odd one out is the finding of Jonathan Ball. I think I'm right in saying that's the only time an inspector has ever found there to be a 5-year supply in Waverley since at least 2017. So the idea that, say, accidentally during the course of this LPP2, despite not needing to, in his view, to demonstrate a 5-year supply, it's found one, lacks credibility. There's a further point, of course, which in reality, given the blatant time provision of this material, the limited time we've had to interrogate it, the 5-year supply plainly hasn't been interrogated and tested in anything like as considerable detail as it would have been in that succession of decisions when there would have been cross-examination, considerable roundtables, day-long roundtables, as often is the case, etc. So the assumption made by the PPG and made by the Inspector Board that consideration of the same test in the local plan context would be informed by better evidence simply isn't good in the context of the material before you. There's also the point, sir, that in relation to, I might as well get all my main points out over now. In relation to windfalls, we are going to hear about later. What the PPG requires, we deal with this in our reps, in our consultation reps on Regulation 19. But the framework requires, at paragraph 71, compelling evidence in relation to windfalls. Now, that plainly is a more demanding test than the clear evidence for category B identified sites, because windfalls are one further move away. So it would be perverse if the test was lower for unidentified sites than it was for identified sites. So compelling evidence is clearly more than clear evidence. We know from the various succession of decisions in relation to clear evidence, the assertion isn't good enough, you need to back it up with evidence. And the compelling evidence for windfalls has to be, have regard not just to past rates, but also to expected future trends. So the compelling evidence has to look backwards as well as forward. And yet when you come to look at the very limited scanned material that Waverley had put forward justifying its windfalls, it's only looked backwards. There's no compelling evidence or indeed analysis of why it is that that the claimed windfalls, 72 for the last 2 years, will be delivered. It's simply a backward-looking exercise. Then finally, sir, the need for speed. We've covered this at various junctures during the examination, sir, but given the reasons I've said on other days, there is a very important public interest in LPP2 delivering quickly for the reasons canvassed. It was firstly because it's come later than expected, and therefore even if the council is right that it should allocate more sites, it's clearly already overdue in making the allocations that it does contain. And if we're right that the slack needs to be picked up, then again, that needs to be done quickly because there's an urgent shortfall. Now, for those reasons, it is troubling that as currently proposed in the trajectory, the LPP2 allocations don't start delivering until the latter part of the 5-year supply period. At best, that's on the council's own case. And further, that need for speed reinforces what Mr. Neame said about the complete unacceptability of the Lichfield, the Liverpool opposed to Sedgefield approach to shortfall. Plainly, as was the case previously, the Sedgefield approach should be preferred. So those are my observations, sir. Thank you very much indeed. I'll now put myself back on mute.
Thank you, Mr. Banner. Mr. Berrant.
Thank you, sir. As I would agree with many of the points that Mr. Neame made, including my own generous assessment with regard to the housing supply. In terms of the approach I looked at, it was to say, was really around Dunsfold in terms of what that position would be if that were to deliver as per the Scotland Lane appeal hearing. And what was clear from that is that just by altering that estimate alone, that the council, and also Mr. Neame's in terms of the outstanding 10 plus, because again, like Mr. Neame, I found that was wrong and adjusted that. The council would have a shortfall of 466 homes on the basis of the land supply, and there would not be a 5-year land supply on adoption or for the remaining plan period. So I think it's that point that is concerning, is that there isn't the flexibility in supply to be able to address what are very clear risks that site will not come forward as expected by the council. And I think if we look at the evidence in terms of the outlets and delivery, the council are looking at 68 dwellings per annum per outlet. And we look at the Lichfield's work, and that states in that work that it's going to be about 45 dwellings per annum per outlet. So it's a significantly lower number. What we also find that there is likely to be a range, and there is a range within that work, sir, and that is in figure 13 of the Lichfield's work. And it ranges from between 20 and about 70 dwellings per annum per outlet for 3 outlets on site. But that's a significant range, and it's clear that the council are looking at very much the upper end of that range. So it is, if it delivers optimally, it will deliver that. And that doesn't take into account those risks that have been set out by Mr. Neame and are clearly there. We shouldn't be looking at optimize, we should be looking actually what is likely to happen rather than what will happen with a fair wind and optimally. So I would suggest in terms of looking at that in terms of even a very generous view on this in terms of the other elements of supply, the council will still not be able to meet housing needs in full. They won't be able to have a 5-year land supply, and as such, it needs to be rectified. And we should be looking at this plan to address those shortfalls. It was the point at which those issues with the supply at Dunsfold, which were evident coming forward, should have been addressed and weren't. And all we have now, sir, is a decision to move to a Liverpool supply trajectory rather than required Sedgefield to try and get that 5-year housing land supply, all because rather than seek to address the problems, the council have looked to try and adjust the level of supply from each of the sites in a way that seeks to try and address that, rather than actually look to address the problem that was actually there, sir. Thank you.
Okay, just before I bring others in, there's been reference to a number of people about the Lichfield's paper. I wonder whether that could be added to the examination library. I'm aware of it from other examinations, but if that could be added.
So yes, of course, we'll certainly put it in, and you will be aware of, for example, the comments made about it, and it's whether or not it is sufficiently local to deal with areas like, for example, mid Sussex, where Inspector Fox took a view about that study. But as you go back through his report, you'll see what was said about it there, and we would say that those observations apply with at least the same force to Waverley.
Mr. House.
Thank you, sir. Can I just check? It's saying that the video, I check you can hear me. It's saying the video isn't working because it's the host has stopped it, but we'll just hope that works. There we go. Thank you very much, sir. Can you hear okay?
Yes, that's fine. Thank you.
Good. So I hope there's just one point I wanted to clarify from last Thursday. This is all concerning the Milford Golf Course site. You asked me on that occasion after my submissions whether there was any possibility that in the longer plan period, if the lands tribunal process has gone through, that there could be some development on this site. And I think my answer was unclear because I interpreted the question as asking me effectively, how long is that lands tribunal process going to take? And I think that's what my answer focused on. The answer to your question then on Thursday in my submission is that no development can take place pursuant to the current plan unless and until the covenant is discharged. So I just wanted to be clear on that. For reasons that I can go into, but it sounds like it may not be necessary, there is a very low probability that the covenant will ever be discharged, and there is no evidence before you. This is a point I do want to emphasize. There is no evidence before you that it will be. The certainty is that any application to the Lands Tribunal were one to be made, and it hasn't been made in the last 4.5 years, nor in the last 9 months since the full planning permission was given. That it will take at least 15 months from inception to be determined. And the point is that the very high probability in my submission is that when it is determined, then it will fail and the covenant will be upheld. Now, legally, a covenant compliant development of 27 households could be built on that site in the longer plan period. But 4 points about that. One is there is no evidence of a developer that wants to do that or a house builder. There's no planning permission for such a development. There are many experts in the room who'll know far better than me, but my submission will be that the planning permission will be unlikely to be given. And actually the whole basis of the removal from the green belt and the designation of LPP1 as a strategic site will be demonstrated to have been false. So that was just a point that I wanted to make by way of clarification of the answer that I gave last Thursday. And then, so I wanted, if I may, just frankly, just to try to understand something about the new material that's been presented and now qualified, and to a certain extent clarified for me by what Ms. Dove had to say. But the new material that's been uploaded on the website under references 29 and 30 on the 18th of July does seem to me to be, first of all, exceedingly opaque. But a point of real note is that whereas it does attempt to produce some further evidence of deliverability in relation to the Dunsfold site, it conspicuously does not do so in relation to the Milford Golf Club site. So there is no further evidence put forward, and that supports, I believe, my previous submission that there is in fact no evidence of deliverability. And so, but it does seem to me from that information, and I think it's now being confirmed, that MGC is not included, as I understand it, in effectively the updated local plan Part 1 Appendix C housing trajectory. I want to come on to clarify that, but that's my understanding. And then checking on in the documents that were produced, when one looks at the new Appendix C, the new housing trajectory, the summary of the housing trajectory for Milford and Whitley does include 2,660 outstanding permissions for large sites, and then 320 for strategic allocations in LPP1. I find it impossible to tell from Appendix C whether that includes Milford Golf Course anywhere. But I think I understand Ms. Dove now to be saying something to the effect that, yes, it is included, but for later in the plan period, at the back end of it, I thought I heard her to say 2027 to 2028, but maybe that should be, we could come on to that to get some clarification. But the note that's been produced in relation to this new Appendix C says that outstanding permissions it says that outstanding permissions data, which is then available at Appendix 2, has been used to complete the outstanding permissions on small sites and outstanding permissions on large sites within the categories within the trajectory. So one would presume from that, or I presumed from that until today's hearing, that Appendix 2 would include reference to the Milford Golf Course site with planning permission for 190 dwellings, if any of that number is to be included within the trajectory. But looking at Appendix 2 and looking at the list of outstanding planning permissions, and in particular pages 52 to 57, where they list the outstanding permissions for sites of 10 houses or more, or 10 dwellings or more, it doesn't list anything in Milford or Whitley. So and I think this has been clarified, but I wonder whether we could just get it crystal clear so I really understand the position. Am I correct that the council is now saying that the housing trajectory recognizes that there is insufficient confidence in the deliverability of the MGC site for it to be included in the housing trajectory, and therefore it has been excluded altogether from the housing trajectory for the purposes effectively of this examination and the revised Appendix C? If so, then that in some ways is a sort of an end to the matter, subject to one clarification. And the clarification is that when one looks at the most recent document put forward, the parish housing allocations, which I presume is intended to be Appendix 4 to the updated Appendix C, that lists under Milford and Whitley 188 outstanding permissions. That's in column B. And then it attributes those, of course, to the total commitments of 288, from which it derives the balance needed for the LPP2. But it is completely unclear to me whether in that parish housing allocation, that 188 outstanding permissions includes anything from the Milford Golf Course site. If so, how much? And what is the evidence for deliverability relied upon? And if so, how is that consistent with Appendix 2? So if there is insufficient, if it is accepted that there is currently before you and effectively before the council, insufficient evidence of deliverability to include it in the housing trajectory, then what is the evidence that the council relies on to say that it is developable in the planned period at all? And this is really perhaps the final point I wanted to make, is that the evidence that was before Inspector Bohr in 2018, which on balance allowed him to take a different view about the Milford Golf Course site's deliverability from all of the subsequent Section 78 inspectors who have addressed the issue recently. The evidence that was before Inspector Bohr came from two sources. The first was a legal opinion from WBC's counsel in 2017 on what he regarded as the prospects of the covenant being resolved in favor of allowing development of 180 houses as it was then. And the second piece of evidence were submissions from Savills in May 2017 on behalf of the promoter of the Milford Golf Course site, which was Crown Golf. And I look back at those submissions and they said there are no perceived technical considerations that could not be readily mitigated that would affect the delivery of the site. And it's correct, therefore, that the site is released under LPP1, not under LPP2, as it'll make a valuable contribution to the current housing needs of the borough under LPP2. The council's modification to the plan at that stage to release the site under LPP1 is therefore supported by Crown Golf and ensures the delivery of a sustained housing development not withheld. Well, when one looks at Savills' views now, which are of course 5 years later on, and there's been a lot of, my point is that there's been a lot of development since then, so it's unsurprising that perhaps they've changed, but Savills' view now is that in their hearing statement is that there is also a fundamental delivery obstacle preventing Milford Golf Course on the basis of a land covenant, which in successive Section 78 appeals has resulted in the site being removed from the 5-year housing supply. And so that in one sense is things have moved on considerably, even in relation to one piece of evidence that was apparently impactful on Inspector Bohr. And then the second piece of evidence, there is no, the inspector does not, you do not have, sir, the benefit of any revised view from WBC's counsel or anything from the current owners or developers by way of a revised legal opinion, which perhaps speaks for itself. So that was all I wanted to say just in relation to Milford Golf Course. But I am unclear from the current material exactly why Appendix 4 appears not to be consistent with Appendix 2. And if it is true that there is some element of development presumed in the Milford Golf Course site for later in the plan period, I'm unclear what is expected to change between now and then, and if it's been effectively accepted by WBC that it should come out of the housing trajectory for 5 years, consistent with all of Section 78, what is going to change? So those are my questions and my submissions. Thank you very much.
Thank you, Mr. House. Ms. Ashton?
Thank you, sir. First and foremost, apologies for my late arrival, although I did try and be good and not make so dramatic entrance. I've been stuck on the M25 for everybody's information for the last hour and a half, which was horrendous, and not great prep for this, but still, first and foremost, I'd just like to totally and utterly support what Mr. House has just said about the contradictions there appear to be in the documentation that's been put before you within documents 29 and 30. One clearly indicates no development on Milford Golf Course. The other one clearly relies on it, and it relies on it in order to be able to achieve the overall minimum requirement within the plan period. I won't dwell on Milford Golf Course. I said what I said last week. I think there is a solution to the situation in Milford, even with no development at Milford Golf Course. The only thing I would also like to add is I'm slightly confused if the local authority are relying on delivery at the latter part of the plan period. Yes, there might be an outline planning permission that's been granted and likewise a reserve matters, but they are time limited. And if they are pushing this back to the latter end of the plan period, they will have expired. Perhaps they can answer you on that one, sir. But I want to come back, sir, to the fragility of the housing land supply situation, both in terms of the 5-year housing land supply and also in terms of the overall supply over the plan period. If I can, sir, using the latest information in document 29 and in particular the table that the local authority have provided using the Sedgefield method, I will stick to the Sedgefield method. That is the method that was agreed with the authority during the course of the local plan part 1. It was agreed for the specific reasons that existed at that time. That situation I don't think has materially changed. And the situation in Mid Sussex was significantly different. There they had a step trajectory because of the situation with the Burgess Hill urban village. And that is why in that instance, Mr. Bort agreed to that. And sir, if you wish, you can go to its paragraph 82 of the Mid Sussex site allocations DPD report, which actually touches on that. That was submitted last week. And also in Mr. Ball's main report on the Mid Sussex local plan, in his introductory table, he comments on the modifications to the housing requirement and the need for a stepped housing trajectory and the rationale for that. So the circumstances are different in Mid Sussex as they are in Guildford, as Mr. Neame has already alluded to. So in terms of fragility, if you look at the latest documentation that's been produced by the authority, it indicates that over the course of the next 5 years, there will be a rolling 5-year housing land supply of 5.1, 5.1, 5.2, 5.3, and then 5.2 again. To just put that into context, sir, that means that there would be 47 dwellings over the minimum requirement within 22-23, 119 the year after, 160 the year after that, 214 the year after that, and then 115 the year after that. That, in my mind, is exceedingly fragile. Only one thing needs to happen to throw that out. Now, you've heard, sir, from many people about the situation with Dunsfold aerodrome. We have this week provided information to the programme officer about the situation with the oil and gas consent. And we have queried the fact that Waverley Borough Council have sought member approval through their executive to judicially review the Secretary of State's decision. I'm not commenting on the decision at all. What I am trying to highlight in the submissions I made this week is the apparent contradiction again in the approach that the local authority are adopting. Here, they are suggesting that Dunsfold can come forward very quickly. In their representations to the oil and gas inquiry, they were making specific objections on the premise that that would seriously delay the delivery of that strategic development and the implications it had for them in terms of their housing land supply. Now, Mr. Begland knows that I was going to raise this. I did advise him last night, and I would appreciate it, sir, if after I've spoken, perhaps Mr. Moores can actually speak on the Dunsfold oil and gas exploration situation. Just moving forward, if I may, in terms of other matters that have been raised, again, I'm happy to come on to Windfalls again later on today, if that's appropriate. But I just really want to stress this issue of fragility, but also the fact that we're not necessarily trying to paint a bleak picture on this side of the room. We have suggested before that there are solutions to this situation. I last week put to you a potential solution for the situation in Milford. And again, sir, I did actually ask the programme officer if a table I had produced on that could be provided to you, because it just made it easier for you to understand the maths that I was trying to put across last week. Likewise, I have provided the programme officer with an updated table to my Matter 6 statement, setting out our position on the potential shortfall as it stands at the moment, given our view, not only on Dunsfold and Milford Golf Course, but also on the situation with a number of the other component parts of the housing land supply as set out in this latest document. And like Mr. Neame, I get to a situation whereby we are at a deficit of around about 1,500 units. As I say, there is a solution. That solution includes the potential allocation of sites that have been identified through Reg 18. So it is a solution that is, I would suggest, palpably simple for the local authority to proceed to look at if you were to recommend main modifications along those lines. The only other thing I would like to say is that when looking at that, it would also, sorry, I've lost my train of thought. When looking at that, it would also be helpful to review the situation as it stands with the other strategic settlements. Again, others have made representations to you about the position within the local development scheme and the scope of the local plan part 2. The local authority within their own Matter 6 statement accept that they have themselves restricted the local plan part 2 to their own scope of works, but they could actually have provided for a wider delivery area. And if you do that, then, sir, there are others around this table promoting sites within the main settlements that clearly could provide for that. And again, going back to Mid-Sussex and the inspector's report on the local plan part 2, he accepted in that report that there was the ability at local plan part 2 to provide for more within the main strategic settlements, as long as it wasn't going above and beyond the direction of travel of the local plan part 1, I'll put it that way. And say, if Mr. Moores could come in now, I'd appreciate it.
Thanks, Ms. Ashton. You might have missed my introductory remarks where I said I've got everything I need on scope, and I'm well aware of that in terms of what the party's views on that. So I don't expect to hear more about that this afternoon. But Mr. Moores, if this is specifically on the Dunsfold issue, that'd be useful, please.
It is. Thank you, sir. Yes. Can you hear me okay?
Yes, absolutely fine, Mr. Moores.
Thank you. I just want to pick up the point about Loxley Well. I mean, you may well be aware of it. It's been splashed all over the front page of the planning magazine, or indeed, if you read it, the Hazelmere Herald. I mean, essentially on Monday, the council held a special executive meeting where it sought approval of funding to bring a judicial review against the Secretary of State's decision to grant planning permission on appeal to UK Oil and Gas for exploratory drilling at Loxley Well near Dunsfold, and essentially the oil exploration takes place under the Dunsfold aerodrome. So the council approved that funding of some £13,500 plus a contingency of £4,000 just in case a judge on the paper doesn't find their application attractive and they have to renew it orally. This is relevant because the council's position in opposing Loxley Well, including the evidence it adduced at the inquiry as a Rule 6 party, because of course it was Surrey County Council as the Mineral Planning Authority that was the determining authority, contrasts with what the council's case now is to you, sir, on the deliverability of Dunsfold. What the council said, and this is quoting from the inspector's summary of its case at the inquiry, is that exploratory drilling directly under Dunsfold aerodrome would potentially be detrimental to the delivery and viability of this strategically important site, with consequent impacts on the delivery of a very substantial amount of housing within the borough. Now, the Secretary of State granted consent for that exploration on the 7th of June, subject to two conditions in particular. One, it's got 3 years to implement the consent, and it's a consent with a duration of 3 years. So that's potentially 6 years during which the Dunsfold housing site is affected by this oil exploration. The key point is that the council's position in the JR is squarely at odds with its position on delivery in its evidence to you. And frankly, the council ought to explain that. And it's surprising, to say the least, that none of the council's concerns about impacts on deliverability, which it's apparently now pursuing through the courts, have been aired in this examination to you, sir. So that's the point. They envisage houses springing up out of the ground left, right and centre imminently, but on the other hand are judicially reviewing the Secretary of State because he didn't accept their case. The spectre of the oil exploration would stymie the development. So we've got all the relevant documents. They are all publicly available. They were cabinet papers for the meeting on Monday, which we can put in, but that's the essential point, sir.
Okay, thank you, Mr. Moulds. I think it'd be a good point to adjourn now. If we take just a quite a brief break and come back at 3:45, and then I'll hear the council's responses to those points before we move on. Thank you. Okay, if we could resume. So if I could ask for the council's responses to those points. And one thing I'd be interested to hear as well in terms of that response is we've heard Ms. Ashton's view on the tight supply situation over the remaining plan period. And this also goes to discussions we've had previously about the figures being referred to as expressed as at least figures in the part 1 plan, and whether the part 2 plan could be doing more in that in terms of either providing a headroom or a larger buffer in terms of the requirements it seeks to make. So that's one marker from me, but also your general reflections on the other things, please, Mr. Beglam.
Oh, so that's helpful. Mr. Longley's going to kick off.
Thank you, sir. I'll duck around a bit in terms of the issues that I pick up, and then Ms. Dove and Mr. Beglan will contribute more and pick up issues. I'm not going to repeat anything about the scope of the plan, but obviously our approach to these matters is very much guided by the role that the Part 2 plan has alongside or underneath the LPP1 and alongside the neighbourhood plans. The first issue, so if I can pick up, is in relation to Dunsfold Park and the comments that have been made in relation to the deliverability of that. Clearly, this is a nationally important scheme. It's part of the government's Garden Communities programme. The council has been supported in its work through that programme, and it is a fundamentally important part of the spatial strategy for Waverley Borough, and that was recognised in the LPP1 inspector's report, and so I can give you the references for that, starting at paragraph 35, where he notes that Dunsfold aerodrome development will allow significant development on brownfield land, reducing the need to find further SAN and greenfield sites, and goes on to talk about the limited impacts on valued landscapes or habitats, and the highway impacts are capable of mitigation. So the delivery of 2,600, as it was then, through LPP1 on Dunsfold aerodrome brought all of those benefits with it, and was a particular spatial strategy. I think what you're being invited to do by some of the participants is to look at a different strategy, which is redistribution of some of those numbers from Dunsfold Park across sites, either within the areas we're looking at in LPP 2, or indeed more broadly across the area. And what I'd say, sir, is that is a different strategy. It doesn't necessarily have the benefits that the inspector identified through Dunsfold Park, and it also creates difficulties in terms of the council's approach and acceptance of what were very ambitious housing numbers. And so it's probably having said that, at that point, it's just worth reminding ourselves as to the origin of those housing numbers, which I would say are positively prepared, ambitious, but hopefully deliverable numbers, which, as set out in the LPP1 inspector's report, arose from demographic projections plus a significant uplift to help with affordability. And then on top of that, half of Wokin's unmet need, and also an element of adjustment for additional migration from London. So we ended up at that time with a number that was 50% above the base demographic projections. So I think it's wrong to portray those numbers, which then obviously come to us into LPP2, as being anything but positively prepared and ambitious. And just as a note, in terms of what's currently being delivered, over 600 homes a year is in line with those numbers, and it's around 4 times the levels of delivery that were envisaged in the 2002 plan, when of course we had a regional spatial strategy and a structure plan that sought to direct growth away from more constrained and greenbelt areas. So that's just by way of an aside, because I think it's very easy to just take the housing numbers as a given, and I think that explains to some extent why the council has sought to meet those minimum requirements, but hasn't created, I think your words, so were the sort of headroom, significant uplift above that, albeit the word in the policies is minimum numbers. So if policy compliant schemes come in within those named settlements, the plan won't be used to constrain those. And it's also worth noting that neighbourhood plans can, should they wish, plan for additional housing above that. And I think we've already seen with the Farnham neighbourhood plan, I think there's something like 8% above the minimum requirement is being planned for, and they're there, and Bramley too, but that's a small number of dwellings over their numbers. So I think the neighbourhood planning groups are taking the plan in the spirit in which it's intended and not overly constraining themselves. So coming back to Dunsfold Park, the Bidwell's evidence that we've provided, and I apologise, there is a typo. It's not our typo, but it came through with the evidence. It is this year's evidence, 2022, and that provides the latest position on behalf of the promoter. And I think in response to Mr. Neam's point, it is worth noting that Trinity, the landowner, actually own. My understanding is that they own DAL, who are promoting it and are obviously continuing to put in place all the make all the steps that are needed so that when the new owner is confirmed, they'll be in a position to move forward quite quickly. And alongside the efforts that are set out in the Bidwell's notes, obviously the council has done and is doing everything that it can to enable that development. And I thought it was already in the examination library, sir, but we will put the supplementary planning document in there if that's of interest, because it is a good piece of work, and it provides a context for future planning applications. It doesn't require, as I think was said, new applications, but it will be the framework for guiding the preparation of those. In relation to the point that's latterly been made, and we received some information last night around the exploratory activity that's been consented at Loxley Well, it's certainly the case that the Borough Council did oppose that, and you've been provided with the documentation there. And within that, it did express concern over the implications for the delivery of Dunsfold Park. But I think the important thing to say there is that view and that evidence, and the evidence presented by other opponents of the scheme, was considered by the planning inspector appointed by the Secretary of State, and his report by the Secretary of State, and that matter was considered, and the conclusion was that the exploratory drilling at, I think, somewhere 800 metres away from the site would not have an impact on the deliverability of the scheme going forward. And obviously, that planning consent for exploratory activity does not presume that if reserves are found that are viable, it makes no assumption as to the acceptability of any future planning applications in relation to those. So I think I'll leave Mr. Beglin to comment on the council's issues around legal challenge on that matter. But that's the position. So honestly, I think it's something of a red herring at this point, because the issue has been determined by the Secretary of State. In relation to the golf course issue, perhaps if I could turn first to Ms. Dove, perhaps to clarify that position, because I think there is a point of clarity needed.
Thank you. So in terms of the Milford Golf Course site, I just wanted to confirm that the site should have been included in the list of outstanding planning permissions. So the data that we use to create the list of outstanding planning permissions is from our 5-year housing land supply position statement that for 2022, which hasn't yet been published, but it should have been included. And the reason it wasn't included is partly an oversight on the council's part, but also because the site at Milford Golf Course is no longer considered to be deliverable within the first 5 years, and therefore has been included within the housing trajectory Appendix C, the updated one, for provision later on in the plan period. So it still forms part of the supply, but not in the first 5 years of the plan period.
So are there corrections that are required to be done in terms of this paper?
Yes, we can provide an update on the evidence. That's not a problem.
Mr. Long, I'd just like to pick up, I mean, I touched on this point last week in terms of the spatial strategy, and it's well understood in terms of how that spatial strategy was derived in the LPP1. But it's an open question, really, in terms of what happens to the spatial strategy if there is no 5-year supply and then appeals are coming forward. So is there, in that context and thinking about that, does LPP2 need to do more in terms of a plan-led approach to that?
I think so. The plan obviously contains policies that guide development, and if we have to revert to the national planning policy framework, then that too would guide development to the most sustainable locations and obviously protect the most important aspects of the environment. I don't think that's necessarily going to be better achieved by seeking to redesign LPP2 to address matters that it wasn't intended to design. I think the best thing that could be done, and picking up on Mr. Bannon's point for the need for speed and the urgency, is to put LPP2 in place with its allocations, which will make a very real and important contribution to housing supply, and the pace at which sites are taken up, given the strength of the housing market, gives confidence that is going to deliver an ongoing supply of housing.
Thank you. And Mr. Beglan, any further points?
I'm not sure Mr. Longley's departure to his staff indicated that he finished what he wanted to say. He may have done, in which case I'll jump in, but it may be he's got a little more.
Not a great deal more, sir, and we may overlap a little bit. But in relation to the point about Lichfield, I think we'd ask you to refer to the Mid Sussex report. Clearly, Lichfield's piece of research looked at sites across England and Wales of various scales and in various housing market conditions, and I think by any measure, Waverley is probably one of the strongest housing markets in the country, and we would expect once a site is such as Dunsfold Park is brought to the market with deliverable parcels of land, it will be built out fairly rapidly. And obviously the delivery rates that you're talking about now, I think they're suggesting 260 per annum as a maximum, which would include any number of outlets. I think they've talked about 3 initially, but on top of which there may be an element of customer self-build and potentially other forms of housing delivery. I think they mentioned extra care housing, but there's clearly some work to do, but we don't think that those rates are by any means unrealistic, looking at Lichfields and the sites that they looked at within that in stronger market areas. And so if it helps, we could provide our analysis on that for you.
Thank you, Mr. Long. Mr. Beglan.
So then 6 points from me. First of all, in relation to Liverpool versus Sedgefield, when you go back to Inspector Ball's report and the position that was agreed and progressed through Local Plan Part 1, you'll see how integral the reasonable assumptions which Inspector Ball considered at that stage about Dunsfold aerodrome, and but plainly he thought they were reasonable assumptions, he said so in terms, were central to the local authority's ability to provide the levels of housing that were being contemplated by LPP1, including the very significant uplift to take into account Woking's unmet need that you're familiar with. And you can see that, for example, at paragraph 53 of his report, which is one of the mentions of the approach to Sedgefield. So, and I'll ask you to review that. And so following on from that, and again, noting the centrality of Dunsfold to the appropriateness of the application of Sedgefield, he noted the whole sequence of advantages that Dunsfold aerodrome had. And Mr. Longley's referred you to some of the earlier passages, but if you look also at paragraph 77 through to 81, the inspector sort of returns to his theme there in relation to the delivery advantages that Dunsfold had and why it was reasonable to think that it would be making a contribution relatively early on after the adoption of LBP1. So that's the first point. And so that being a fundamental part of the calculus, that has changed. We know that. The question is, what do we do by way of acknowledgement of it? Do we put the local plan part 2 on the assumption that it needs to make provision for 5 years worth of housing land supply in a position where it is more likely to fail and thus encourage section 78 speculative development? Or do we approach it using the essence of the logic that commended itself to inspectors elsewhere? Mid Sussex is one example, and that the 2 planks of the logic do apply. I say, of course, then it's not an identical position, but the 2 essential planks of the logic that was employed there do or does now apply here, and it's also consistent with PPG guidance. So that's the first point. The second point, just on Dunsfold itself, and you've heard from Mr. Longley on this, but it's worth observing that of course different inspectors have actually reached different views, their own different evaluations and assessments of the sufficiency of the evidence in relation to Dunsfold. You can see that in the 3 decisions that are in front of you by way of development management, and Inspector Hockenhull was quite content for there to be a contribution from Dunsfold, albeit pushed back later into the trajectory. And so what I would say in relation to that is that when you bear that in mind, you assess it for yourself, reaching your own conclusions. You take into account the inherent advantages as a site moving forward that Dunsfold has in terms of the topography, all of the things that are mentioned, the relative lack of constraint, the relative attractiveness in terms of bringing it forward at speed for a site of that size. You take that into account. You can look at the benefit of the SPD, and that is a change in circumstances. From February of this year, anyone who wishes to develop the site has the benefit of the further guidance that the SPD provides and the further certainty, and that will be necessarily attractive to anyone who is considering purchasing the site in terms of certainty of decision making. Risk is something that most purchasers strive to avoid. And we also know that we have the information from Bidwell's, which is a development, and it's a recent, in part, restatement of commitment, but it also deals with matters that are happening on site, which are all consistent with paving the way for the site to come forward in the relatively near future, and certainly within the planned period along the lines that we have suggested within the trajectory. And of course, again, it's just a function of the exercise that a number of the individuals around the table now will wish to make criticisms of the information that's been provided by Bidwells, but there is no reason for you to look under that information. And one of the observations that Inspector Ball made during his report was that that is, on the face of it, the best source of information. You go to those who own the site or seek to promote the site, and that is where, as it were, one ought to start with investigations, and it may well be that they provide a level of information that's sufficient to persuade you, as indeed Inspector Ball was persuaded on the basis of what was being said then. So that's the second point. The third point is in relation to Lichfield. So I'll deal with this very briefly. You've already got the flavour of what we say about that. Mr. Neems says it's really the only credible source that you can use for this kind of situation. We say no. Look at Mid Sussex and look at what Inspector Ball did as well. Page 23, paragraph 88 of his report. He looked at Campbell as an appropriate comparator for the reasons that he set out there. So when we look at the fact that the Lichfield's work provides for a range, again, even if one were to suggest that we might be towards the top of that range in what has been suggested, that would not be surprising given the strength of the market in Waverley, as we know. And that's all I wanted to say about Lichfields. But the fourth point is perhaps an important point. A number of the objectors then say, well, this is an issue that needs to be rectified. And so you have to consider how that exercise is to take place. And we say that that is not the correct response to even a conclusion that there is a difficulty in terms of 5-year housing land supply here for reasons that we have already rehearsed. But I do go back very briefly to policy ALH1 in part 1 of the plan, page 48, and to make 2 points about that. Firstly, if, as appears to emerge from what the objectors to this plan have said over 2 consecutive days now, where we've been debating these issues, the overwhelming substance of the point that comes through is, well, Dunsfold has become the problem here. Might not have been the problem. It was an integral part of the solution at the time that LPP1 was coming forward, but it hasn't delivered as was anticipated at that stage. So that's where the problem lies. If that's right, then the inexorable logic from that is that the solution is in looking at the strategic policies. Dunsfold is an absolutely integral part of the strategy here. So the answer is not to go beyond, not addressing scope, but we say it's beyond the scope of this plan. I'll leave it there. But the answer is to deal with it by way of the review, which will take place by February of next year. And in the meantime, what will have happened is the completion of LPP2, bringing with it the very significant benefits that it offers. And if there needs to be a more fundamental reconsideration of those strategic issues, then LPP1 is the place for it to be done, or the review of LPP1. The second point that arises, which is related to that, is that it's worth reflecting on just how, if not prescriptive, then descriptive policy ALH1 is. It gives numbers in relation not only to the main settlements, but also to the large villages and indeed the small villages, dealing with the windfalls last of all. So in relation to the amount and location of housing, which are the 2 things that we say really can't be divorced when we're considering these issues, we can see how much detail was being given in relation to where the housing ought to go. And that, we suggest, was a carefully calibrated approach. And so the superficial attraction of it being said, well, look, we've got a ready-made package for you here, sir. There is a straightforward solution to this problem, actually it doesn't overcome the very careful way that the distribution of housing was being advanced under LPP1. So those are the 2 points I wanted to make on the rectification point. In relation to the statutory challenge that the council has recently given its authority for, you've heard about the way that the Inspector and Secretary of State resolved such complaint as or concern that there was expressed by the local planning authority, consistent with what residents were saying about a risk of some delay to Dunsfold. And in terms of the factual conclusions before you, the short point is that the inspector didn't agree and the Secretary of State didn't agree. So that's the end of that point as an evidential point. And moreover, in terms of the judicial review that's being taken forward, or sorry, the statutory challenge, the challenge involves a number of grounds, but none of which criticise as being erroneous in law the approach the inspector took on that point. So insofar as there is a suggestion that what is being pursued by reference to that challenge is inconsistent with the evidence you're being given here about delivery at Dunsfold, that's not right, because those matters are entirely legally beside the point in relation to the challenge that's being made. And then, sir, finally, you invited our attention back to the at least formulation and the idea of headroom. And that comes back to the point about calibration that I've mentioned. It was something that could have been considered perfectly properly as a strategic issue, as it was in Guildford, for example, when these matters were being debated at the Part 1 stage, and there was no suggestion that, or nothing carried through into the inspector's report to say that there needed to be further provision so that there would be a greater degree of headroom in relation to housing matters coming forward. And again, if one thinks about the consequences of that argument being advanced now, what it's doing, albeit by a slightly different route of reasoning and logic, is again to say, well, that the key element of Dunsfold is not performing as was expected. Therefore, other alternative provision needs to be made. And so that is, we would suggest, inviting you by a different route to go in exactly the same direction and, as it were, upset the spatial distribution that was a key element of local plan Part 1. And of course, the test, assuming it applies, is 5 years worth of housing land supply. The obligation is not to provide more. And so beyond that, it's not a matter of soundness in relation to headroom. It becomes a matter of choice for the local planning authority. A local planning authority might choose to do more. But if it makes the choice that the distribution is such and the nature of the daughter document in LPP2 is such that at most, as it were, it doesn't want to exceed 5 years housing land supply in terms of the allocated provision. Of course, more may happen by way of planning applications coming forward where they're otherwise consistent with the plan or material circumstances indicate otherwise. But in terms of the planning process itself, plan making process, there could be no soundness objection to that, bearing in mind what was said in LPP1. And so again, it will always be the case that if a local planning authority decides that it is content, as it were, to have a relatively tight position in relation to 5 years housing land supply, that there is a commensurately greater risk, if things go awry, of Section 78 appeals. But that goes beyond a point of soundness to a point of choice for the local planning authority. And here, bearing in mind the presence of the review and all of the features that we've mentioned of the very fluid situation in terms of strategic planning that is before you, the authority is not seeking to go further than that in terms of its housing provision at this stage. So I will look back along the road just in case I've missed anything that I ought to have said. So thank you very much.
In terms of the challenge to the decision, how much of that is publicly available and how much could be put on the examination library?
Well, so I think that's the difficulty, in the sense that some of it is public, some of it will very shortly become public as well, what one expects in terms of the challenge. So there may be a difference between what we can put on now and what we might be able to put on within a relatively short period of time. It's not clear to me that we can necessarily put the grounds of challenge on now. That's something I would need to go away and confirm, but I suspect that's something that we ought to be able to put on the website in due course.
Okay, Mr. Neame.
Thank you, sir. Just a few points just from notes that I've taken as we've gone through, if I may. So not going over old ground, but so just the point that I think both Mr. Beglin and Mr. Longley made about those on this side of the table, as it were, on the screen, inviting you to consider a redistribution of development across the borough. So that's categorically not what this side of the table is seeking for you to do. There isn't a need to do that. There isn't a need to revisit the spatial strategy. And actually, Mr. Longley, I think, answered in a question you raised on what happens if there isn't a 5-year supply, that, well, sites can come forward if they're in sustainable locations, presumably pursuant to the spatial strategy. So effectively accepting what we're putting to you, sir, that if there is a need to allocate more sites, those sites can come forward in sustainable locations pursuant to the spatial strategy. So that's the first point, sir, and actually that's endorsed in Inspector Ball's report, paragraph 57, where he talks about the risks to supply, and in particular the variations to the start date and delivery rates of Dunsfold aerodrome. And that's where he is then directing that the council needs to adopt a positive approach towards housing provision and so on. I won't go back through that. We've been through that report in quite a bit of detail. That's the first point, sir. I think then in relation to Lichfields, it seems to me a bit disingenuous that the council are suggesting to you that a very well respected and up-to-date piece of empirical evidence is in some way not relevant here, particularly because I've been in numerous Section 78s with this authority, where this authority has sought to apply delivery rates from various iterations of the Lichfields documents. And I think the corresponding point to that is that you were invited, quite rightly, to take your own view on the evidence that's been presented in relation to, amongst other things, Dunsfold. And Mr. Beglin quite rightly raised the fact that different inspectors have reached different views on the delivery from that site. That's correct. What is a common factor, though, is that the majority of those inspectors that have considered the Dunsfold situation have disagreed with the council's position. Whether they've agreed with the appellant's position or not varies, but they've reached their own view, as indeed they should do, and that view has disagreed with the evidence the council has presented. And so that in part relies on evidence, including Lichfield's reports, and you can see that from the various appeal decisions that have been submitted. So that's all I wanted to just pick up on in terms of Lichfield's. And then I think just a more general point. In the feedback that you've had, there's been no answer to the impact of the sale of Dunsfold by Trinity College. No answer in terms of the delivery evidence that we and others have sought to rely on, and indeed your colleagues in Section 78 have sought to rely on. The material in front of you just simply is insufficient. And it's not, I think, right to refer back to, as Mr. Beglin has done, to the position that Inspector Bohr reached, because of course we have to bear in mind that Inspector Bohr was assessing the local plan part 1 against the 2012 framework and the footnote 11 test that was applicable at that point in time. We're in a totally different national planning policy framework world now. I'm just going to check down my notes, sir, but I think that was it. I was trying to keep it short. Sorry, yes, so there was just one supplementary point. I think there was a point made to you about the fact that this is a very strong housing market in Waverley, which of course it is, and as I set out, it is the most expensive place to live in outside of London. And that in some ways should give you confidence in the council's figures. But of course, as I'd already set out, the council's figures don't add up. If you apply the Bidwell's evidence, it doesn't actually get you to 260 dwellings per annum. That's the first point. But then secondly, that isn't sufficient in terms of giving you clear evidence of the delivery rate that the council seeks to rely on. You've got no house builder here telling you that the rate that they're able to deliver. And nothing underpinning the assertions that have been made. I will stop at that point now, sir. Thank you.
Thank you, Ms. Ashton.
I hate going second. Totally endorse what Mr. Neames just said. Just in terms of the Bidwell's figures, 68 dwellings per annum on 3 outlets would be 204 dwellings per annum, not the 260 that is set out in the trajectory. Just in terms of the trajectory and Miss Dove's comments about the correction that's been made for Milford, I also just wanted some clarity, if I may, through you, sir. The document 29 trajectory, the Sedgefield direct trajectory, provides overall for 259 dwellings over and above the minimum requirement. Whereas if you look at document 30, that provides for 754 over the minimum requirement, in part because it provides for 2,600 at Dunsfold, not the 1,905 that is now being accepted in document 29. So again, there is confusion as to exactly what Dunsfold is going to deliver and therefore the implications it has on both 5-year housing land supply and the overall trajectory. But again, just as Mr. Neames said, in terms of our position, we're not saying Dunsfold shouldn't happen. We're saying that Dunsfold isn't going to deliver as quickly as the local authority expect, and therefore you need to provide for additional sites to come forward to help address that shortfall. They can come forward in accordance with the spatial strategy and protect the local authority from Section 78.
Mr. Chapman.
Thank you, sir. I completely concur with what my colleagues on this side of the table has said, in that we're not looking to undermine the spatial strategy in any shape or form, but there is the very real recognition that it isn't going to come forward in the timely manner that everyone had hoped it would do. But I must admit, I'm a little bit surprised with the local authority in its stance, in that it has an opportunity to at least try and address the housing shortfall that it has. It is an unfortunate habit that year on year we go to appeal and we're fighting with the local authority with regard to its housing land supply. And again, I'm finding it, I think the people of the borough deserve better, that the council strategy that it's set out, it either looks to address it and bring forward its plans in a timely fashion, and look to make more allocations so it knows exactly where the development is going to be located, rather than sporadic development to be taking place through appeals, which, you know, it's this lack of certainty that we all find so very frustrating. And to put the cherry on the bun, we have the local authority setting out its position that it always has a suitable housing allocation when it clearly doesn't. Thank you.
Thank you, Mr. Chapman, and Mr. Busey.
Thank you, sir. I'd just like to very briefly touch on document 30, the parish housing allocations, and just further to what Mrs. Ashton has just said. My instruction from my client goes only as far as Cranley, so I've delved into those numbers in a little bit of detail. Column B, outstanding permissions, has a figure of 721 for Cranley. I'm not entirely sure where the evidence is that sits behind that, but if you compare it to Appendix 2, which is document 29, there isn't a total shown there for Cranley, but I've taken the effort of adding those up, and there is a difference there, only a difference of 16, but the total is 705 in Appendix 2. Of that 705, many of those permissions are due to expire very soon, some this year, some the early part of 2023. I'm not going to rehearse the comments I've made last week. You don't want us to touch on the scope, but this is obviously in the context of a plan that was adopted nearly 5 years ago, a plan period that began 9 years ago, and in the context of Cranley, a neighbourhood plan that's been in the process of being made for 9 years and is nowhere near examination. I won't repeat the representations and the solution that I suggested last week, but I don't think I don't think my question has been adequately answered. And even if we go with the evidence that has been put forward, Cranley itself stands out as its need not being addressed in document 30. Thank you.
Mr. Berend.
Thanks, sir. Just a very, very brief point really with regard to the council's response about the importance of Dunsfold within the spatial strategy. And I think that is something that I wouldn't disagree with, but I think it is that importance and that reliance on Dunsfold that has created the problem that we have today. And I think it is an over-reliance on Dunsfold and not having a significant buffer and not having that additional supply in place that has created the problem. And that's why it's important to come back to this position, and it's a position that we've all raised, is this is the point at which it should have been addressed, recognising that actually what was said and what was expected from LPP1 had not been addressed and not been delivered. And it needed that buffer, it needed that additional supply to ensure that the plan was deliverable. And I think that is the thing. Ensuring the plan is effective, it can be delivered across its plan period as set out as required by MPPF. And I think that is fundamentally the point. The strategy and having Dunsfold is important, but it's important to ensure that needs are met in full, recognising the risks of placing such reliance on one key site. Thank you, sir.
Thank you, Mr. Banner.
Thank you, sir. I wanted to come back on one point alone. I adopt what's been said in relation to others by Mr. Lee, and that was on what Mr. Beckett said about soundness. He said, well, there's no reason why they couldn't have promoted a plan that didn't go beyond the at least figure. What Mr. Beckland has failed to grapple with is the point I made several days ago, to which there still is no answer, which is that for a plan to be sound, amongst other things, it must have complied with the requirements of SA and SEA. And to do that, it must have tested the reasonable alternatives. The reasonable alternatives here plainly include, given the at least figure, allocating a higher number for that reason as well, even if the picking up the slack argument isn't accepted. But for that reason alone, the at least reason, a higher number of allocations is a reasonable alternative. It hasn't been tested. And that does go to soundness. And there's simply no answer to that for reasons given before. So I'd just like to remind Mr. Bevan of that point.
Thank you. Ms. DeHaan.
So thank you. Just to support what's been said on this side of the room about the difficulties, and to preface what I imagine we'll get on to later in terms of specifics in relation to sites, but just to say something more general about the solutions, certainly in relation to Whitley and Milford, and picking up on what Mr. Beglan said about ALH1. There are a number of sites, of which Petworth Road is one, which form the solution to that particular difficulty. Because you'll be aware that ALH1 and its strategic view, in particular in relation to the minimum number of homes that can be accommodated in Whitley and Milford, encompasses sites like the Petworth Road site, in particular the sites that were benefited, that had the benefit of the asterisks in RE2. Plus there were a number, including Petworth Road, that were previously allocated in the 2018 version of LPP2. So just to echo that there are significant solutions that can be provided within the scope of the spatial strategy in LPP1 that can come forward within LPP2 in order to move this plan on.
Mr. Moores.
Thank you. So just briefly to pick up on the reliance that's being placed by the council on the review of the Part 1 plan, you obviously have our submissions about the scope and the role of the Part 2 plan in trying as far as possible to meet the minimum housing requirement. But of course, you're able to require a detailed review of the Part 1 plan as soon as possible. So far, the council hasn't given any indications or commitments as to the scope or intensity of the review. I just note that given the reliance that was placed on that earlier by Mr. Beglin and his colleagues.
Mr. McEntee, I see your hands up. So this is specifically on the sustainability appraisal point, is it?
It is, yes, correct. It was just to pick up on the point from Mr. Banner regarding how the SA approached the alternatives. Again, I took on board obviously what you said about not rehashing previous arguments. It's set out in our response that the SA didn't seek to reopen how alternatives were dealt with in LPP1. We still think that is a robust approach. And it was also a robust approach to take the approach that we took, which considered alternatives through the large number of sites. I would point out that it's not the role or duty of the SA to go beyond or to suggest extra sites. It's the duty of the SA to consider alternatives which secure the objectives of the plan, and we would contend that the approach taken does that. I can see Mr. Vanner has something to say.
Let's come back on that point, sir, because that's with respect, that's misleading, because you'll recall the stated objectives of as set out in the SA included the at least figure. And therefore incorporate the potential as a reasonable alternative to go up. It's simply not. I've always explained why simply looking at other sites. I did that in the SA section. I won't repeat myself, but it's completely wrong to suggest that it's outside the parameters of the objectives of LPP2.
Thank you, Mr. Bennett. I mean, that point's well understood now in terms of, and I think we're not going to get any further between the parties at this point. It's something I'll have to reflect on.
Thank you.
Further. So yeah, thanks for that. Mr. Beglin, in terms of the other points that have been raised, have you got any final points before we move on to perhaps more detailed questions?
So I'm not sure I do, other than that attention has been drawn to the parish housing allocations, and that really just harks back to the point that I was making about the way that LPP1, LPP2 and the neighbourhood planning process was designed to work in harmony together, and what the parish housing allocation table helps to reassure about is how effective that has actually been in terms of the number of settlements, but bearing in mind that this is 5 years in, only 5 years in, well, less than 5 years in from the adoption of LPP1, how many of those settlements, as identified in policy ALH1 that we were looking at earlier, have already met their targets. And so you need to look through Inspector Ball's report as a whole, really, to see with clarity that that was what was intended in terms of the way that the various parts of the scheme were to operate in that cellular fashion. But you can take a distillation of that reasoning from the Inspector Ball's approach to Farnham. And if you review paragraphs 98 and 99 of his report, what you will recall is that at that stage, when matters were before him, Farnham had not, in fact, reached the levels of development that were required of it under LPP1. Sorry, so if you're minded to look at that now, I'll pause while you...
Sorry, that's fine, Mr. Beglin, if you can continue.
Thank you. Page 25, paragraphs 98 and 99. So what we see there is because at that point in time, in fact, Farnham had not found enough allocations, then there was a need, as Inspector Ball indicated, for there to be further allocations at the end of paragraph 98, either through part 2, unless there was an early review of the neighbourhood plan. So one of those other two mechanisms would be used to address the issue. And then, of course, we know going forward, in fact, there was a review of the Farnham neighbourhood plan, and that by the time we arrive here, that issue has been addressed. So that's, I say you can take it from the report as a whole, and indeed from LPP1. But if you want a clear example of where the point is expressed, that it was this cellular approach that was designed to ensure that the spatial distribution was met, then you have it there. And it answers the at least point as well. The at least point is simply there so that we don't have a system that operates as a cat unnecessarily. And that's ground that we've been over, and so I don't spend any more time on it. But one needs to be careful that those two words aren't being elevated to a point where they support a significant departure from what was a very carefully considered and calibrated spatial distribution. So I'll just check. I think that's the only further observation I had, because tempting as it is, I'm not going to come back on Mr. Banner's essay point. As you say, we've been around those houses. So no, I think that's it from me. I'll just look down the table. So no, thank you.
Okay, there's been some arithmetical comments. If I could ask you to review the information received in the light of those and
So
produce
yes,
an updated.
Yes, where we think those need to be ironed out, we'll iron them out, or where we think that in fact we've expressed things correctly, it just wasn't necessarily as apparent as it might have been if we'd been given a fuller period of time, then we will add some additional notes.
Mr. Neame.
Sorry, so just one really quick question. I did mean to ask it earlier, but Mr. Moores actually jogged my memory. I think it's useful for you, sir. Mr. Beglin mentioned that the LPP1 review would be completed by February. Now, does that imply that there is a review to be undertaken on a technical basis, or was that a slip of the tongue that is it to be commenced by February? Because I think it might be useful for you to at least understand the headline timetable, but also more particularly if there is a scope for that LPP1, because the council are relying on it quite heavily.
Well, as I understand it, there's a difference between reviews and updates, isn't there? So, I mean, what's the thinking on that at present, Mr.
So that's right. I'm not putting forward any further point than that the local planning authority will comply with the regulatory requirements in relation to undertaking a review.
As I said, I'd come back to the windfalls. So you've offered some explanation in terms of the differences in the material presented in terms of commitments and the LAA sites and Windfall. So in terms of an assessment as the plan progresses and has progressed since LPP1 was adopted. So obviously sites are being allocated, and some of those are quite small. So what is that doing to how has that influenced the windfall assessment going forward? I suppose this is going back to Mr. Banner's point on, there's the backwards look in terms of what's happened up to the adoption of LPP1, but then it's what's happened since then and what's likely to happen given the position you are in terms of finding those allocations.
So in terms of how we've calculated the housing windfalls, we base it on completions data dating back to 2003. And we divide our windfalls into small windfalls, which are sites of a net of 1 to 4, and large windfalls, which are and then, sorry, large sites of 5 plus net completions. In terms of small windfalls, we don't count them for the first 3 years of the plan period because that would double count with outstanding planning permissions. And in terms of large windfalls, we don't include them or we envisage them coming forward from 10 years after the base date. 10 years from the base date would take us to the 1st of April 2032, which is obviously outside the scope of local plan part 2. So for the purposes of the housing trajectory and for calculating the housing requirements, we haven't included large windfalls within our calculations because they wouldn't come forward. And the methodology we've used is the same as that in the local plan part 1 process, which the inspector was satisfied with. He didn't raise any concerns with it. We have got a history of delivering windfall sites across the borough, and that dates back from sort of 2003. And because of that history, we anticipate windfalls will continue to come forward. It's also important to note that because the windfalls are only on small sites of 1 to 4, those sites are too small really to allocate in local plan part 2. They would need to come forward as a windfall site, and therefore we do consider it necessary to include windfalls within the going forward within the trajectory.
Thank you, Mr. Banner.
So yes, I mean the giveaway phrase there was because of the history of windfalls, they've been included in the future, and that allied the 2-stage considerations in paragraph 71 of the framework as I outlined. That the past is only one of the relevant considerations. There has to be considerations of whether in fact there would be its compelling evidence of windfalls in the future, the rate claimed. And the 2 things in particular, sir, that are missing, I would suggest, is one, any consideration of how the, whether and if so to what extent, the past windfalls mean that the prospect, the land available for future windfalls has dried up, because ultimately, in reality, we're largely talking about small sites filling holes, whether it's in infill in greenfield or sites in brownfield sites, and there is plainly a prospect that the more windfalls have happened in the past, the smaller the pipeline is of potential windfall for land in the future. There's been absolutely zero analysis as far as we can tell of that, and that's plainly relevant to the second limb, the future limb of the NPPF paragraph 71 test. And the second point, of course, is that there's no analysis of whether and to what extent the rationale for some of the windfalls that have been granted in the past have been influenced by either before LPP1, the absence of the up-to-date LPP1, or since LPP1, the absence of an allocations plan, or further 5-year supply considerations. No analysis of whether the policy climate which has led to the grant of admissions in the past is likely to lead to grant windfalls in the future. Now, it may or may not be the same. The point is there's no analysis of it. There's no quote compelling evidence, and therefore all that is simply being done is very simplistic. It's happened in the past, ergo it will happen in the future, and that level of simplicity is not sufficient, remotely sufficient, to comply with the compelling evidence test in paragraph 71 of the framework.
Mr. Neame.
Thank you, sir. Just a supplemental point, I'll get the word out, to everything that Mr. Banner said, which I fully endorse. I'm grateful to Mr. Dove for explaining the methodology, and it is as I thought, as referenced in the Council's Matter 6 statement. The methodology is the same as that the Council has applied through its local plan part 1 preparation process. The one supplemental point, Sarah, I'd make is that the Council, in the data that it has provided this week, says that it's relying on small site windfalls at a rate of 72 dwellings per annum, with a little jump to 74 dwellings per annum in the final year. The latest 5-year housing land supply assessment that's published relies on a rate of 29 dwellings per annum for small windfalls. And the original Appendix C to the local plan part 1 as adopted relies on 39 dwellings per annum. So there's nothing that I can see, no evidence at all to demonstrate why it is that we've now got over twice the delivery rate that the Council relied on in its 5-year supply assessment in the trajectory that we've been presented with. That was just the supplemental point, sir.
Any responses to those points?
So can I just make a couple of observations? Firstly, obviously the way that we approach windfalls, as I say, was set out in local plan part 1, but it's obviously dates back to the evidence from 2003. So obviously that takes in a number of takes in the cycle, economic cycle. So it's deemed quite a robust approach. And as I said, the inspector at local plan part 1 was happy with that. Appreciate some of the comments which were made about the fact that windfalls may be finite, but there are also changes in circumstances which allows us to be confident that those rates will still come forward. Given actually the change to the prior approval process and things like that, which will all count. The other point is that I think the NPPF changed with regard to its approach to windfalls, with regard to garden land. Before we had discounted them and therefore took quite a conservative estimate towards windfalls, but subsequently with the change to the NPPF, that says now you do need to consider the fact that garden land may have, development of garden land may have an impact. Development may have an impact on garden land, but it doesn't mean you exclude them. So given the evidence that we've got from the contribution from garden land and the policies that we have, which are proactive about development within settlements, it's deemed appropriate for us to still include them.
And have changes to settlement boundary since LPP1 and in neighbourhood plans had any influence on that as well?
There's been obviously small changes to them, and there's obviously been the insetting of some of the certain areas, so there will be some impact. So sorry, I'm reminded there was a big change at Chinningfold, sorry.
So in terms of that, that higher rate that's anticipated. Now the 72 figure, which has that slight uptick to 74 in the last year of the plan period. You got anything further on that?
The reason why there's a slight uplift in the final year is that I think it's more of an arithmetical issue, in the sense that when I divided the numbers, it came out as a point something. Obviously, we can't have a point something of a house built every year. So I've sort of rounded it up and put a higher number in the final year.
Okay, any further points on windfalls before we move on? So moving on now to the C2 housing and how that contributes to the general housing supply. So you're relying on the ratio set out in the housing delivery test rule book in terms of deriving that that contribution. So could you outline the position on this matter, please?
The council considers that C2 uses do make a positive contribution towards meeting the housing supply within the borough, and will continue to do so during the plan period. The MPPG specifically says that C2 uses can be counted towards contributing towards the housing supply of a borough. Obviously, a C2 use, the number of bed spaces in there doesn't equally equate to the same number of C3 homes, and therefore, in order to convert the C2 bed spaces into equivalent C3 homes, we've taken the formula in the housing delivery test measurement rule book to do that conversion, in order to do that calculation. But we do consider that to be a robust method to calculate or make those conversions between C2 to C3.
So, as I understand, that relates to national averages, does it? Is there anything that would sort of weigh in favour of doing a more locally specific approach in terms of Waverley?
I think so. The short answer is we don't have the evidence to substantiate a variation from that national approach.
Okay, is there any other views on C2 and its in terms of the contribution to housing supply? Mr. Neame.
Just one quick point, sir. I wasn't intending necessarily to come in on this, but I think it's important that the balance of both sides of the equation is made here. So can I ask through you, the council is placing reliance on a proportion of accommodation from the C2 uses, applying that methodology. Has the council also therefore taken the same approach where C2 uses are lost to residential in terms of calculating the net loss through that methodology? There are a number of examples that I'm instructed are in existence in Waverley where that has occurred or is due to occur. So has that been taken into account? And if so, where's it documented?
And so what's the approach to that? And in terms of housing delivery tests, is it explicitly outlined in there? I must admit, I didn't read sort of religiously that rule book before we started this session, but I did read the bit that was referred to me. But in terms of, you know, that, whether it be a net increase in that kind of instance, if you've got any views on that.
Yes, the council has taken into account any losses of accommodation through loss of C2 uses using the formula in the HDT measurement rule book. We have, if we're uncertain, we've obviously gone away and done some further research about the previous use of the number of bedrooms, that sort of thing as well. In terms of where it's documented, I don't think there's anything that's been submitted to you that where it is specifically set out. But if you would find that useful, I'm sure we can provide that information to you.
Yeah, if there could be an explanatory note on that supplied, that would be useful. Right, so your Matter 6 statement outlines approaches to mitigation in relation to European sites, and we've touched on these in earlier discussions, both in terms of the effectiveness of individual sites and in terms of the legal compliance of the plan in its soundness and in soundness and biodiversity terms as well. So I'm consequently well aware of the Council's position on this matter. However, does anyone else here wish to make any further points on the mitigation of European sites who hasn't been to earlier discussions on this matter? Mr. Chapman.
Thank you, sir. I have just a very quick observation, which is going to lead into a question. Wilden Heath's Part 2 capacity for development within 400 metres, previously set out by Natural England as being capable of accommodating around 40 dwellings. Natural England has now changed its view on this and has now set out within the 400 metres, Wilden Heath Part 2, the principle of any development, any new dwellings taking place within 400 metres is unacceptable. Now, leading on from that, the Hindhead concept area, which is actually on the Wilden Heath's Part 2, is there likely, and I don't know whether the local authorities had any correspondence with Natural England on this, or whether any assessments been undertaken with regard to its capacity, is there a possibility that the Barron site in particular is likely to be prejudiced by Natural England starting to take a contrary view as to the robustness of the Hindhead concept area in providing suitable mitigation? I don't know if the local authority has been discussed with Natural England on this, and whether or not, like it did with the other Wilden Heaths, it might change its mind, or what the situation is. Thank you.
Okay. Quick answer to that one in terms of the statement of common ground with Natural England, please, Mr. Riley.
Yes, so I think we did actually cover a bit of it through Matter 5 last week. I'm sure Mr. Chapman was talking about the exclusion zone within 400 metres of the Wilden Heath SPA Phase 1, which is mainly around in Milford, where there was a capacity of 40 dwellings, which came about from local plan Part 1 and the HRA, and the capacity was felt appropriate to go up to. And as far as I know, that number has now been exceeded. But Natural England, and I haven't got any formal confirmation of that, but Natural England's advice is that no further development can take place in that 400 metres zone. In terms of Phase 2, which relates more to the Hindhead sites, that's as we discussed last Friday, that relates to the Hindhead concept area, and there was a capacity of 100 dwellings on that. Again, that came from the Habitats Regulations assessment that was undertaken back in 2010. And there is still a residual capacity from that 100 of about 38 dwellings, which means that Barron's, if it was to get its application approved and tried to be delivered, that would come within that number. But after that, then I think there is an exclusion effectively.
Yeah, and the in terms of Natural England's position on the avoidance strategy, that's outlined in the statement of common ground.
Yes, sorry, sir, I should have reminded that. Thank you.
Ms. Dehaun.
So thank you. I suppose it would be helpful for me to know from you, sir, whether it would be useful for you to hear now what I think we want to say something about SANG in relation to the land west of Petworth Road. That is in fact point 3 in 4 points, site-specific points I want to make. I'm happy to make that point now, or just to make my 4 site-specific points together at the appropriate time.
I think if you make all of the site-specific points now, that would be useful. Please.
Superb, thank you, sir. I will happily go ahead and do so. I'll promote my SANG point then to point 1, as it directly responds to the issue that's at hand. One of the things that land west of Petworth Road has to its benefit in terms of being a solution site is that it has the potential to mitigate its impact on the SPA by providing on-site SANG alongside 70 homes, all of those homes outside of the 400-metre buffer. And you'll be aware that Natural England has provided written confirmation dated in April 2018 that the proposed SANG is acceptable, and the 8.4 hectares of SANG could in fact mitigate the impact not just of what's being proposed on the site, but could mitigate the impact of approximately 436 dwellings. And then that Natural England response is appended to our Reg 19 consultation representations. So in terms of the Petworth Road site being a solution to a number of the difficulties that have been aired in this session, that has its benefits manifestly obvious. Secondly, and alternatively, in terms of flexibility in relation to the Petworth Road site, Natural England have also agreed in writing in November 2019 that the development on land west of Petworth Road could be mitigated by the Eashing Lane SANG, which you're aware is within the ownership of the relevant party. And this approach would allow for an off-site solution and a little bit of bespoke on-site solution, which would free up 120 homes, including affordable housing and a community facility on the site. So point 1, site specifically to land west of Petworth Road, is that it has a SANG solution for itself and others. And it is a self-sufficient site ready to go quickly. Point 2 is that it benefits from a clearly defined and highly defensible boundary. And so harking back to something that was said in the last session, when the proper red line is taken into account, the land west of Petworth Road site is essentially the sort of hole in the Whitley donut, really. It fills that in. And third point, because it is the hole in the Whitley donut, it is a highly sustainable site. It is opposite a secondary school. It is within close walking distance of the Whitley shops, the post office, the cafe, the dentist, the infant and primary school. I've already mentioned that the trees on the site are protected within the 400-metre buffer. And the site's also very accessible in relation to public transport, accessible by bus stops into Guildford, Godalming and Hazelmere, and indeed closer to the Milford station than other sites, including Secrets. And had, and this was mentioned last week, I won't dwell on it, but had the sustainability assessment assessed the proper parcel of land and properly taken into account the services in Whitley, this would have been very clear. So it can deliver all of that sustainability plus a community facility to meet local need. And finally, it has the benefit of flexibility because it is not within the AONB, so it doesn't have any of the difficulties in that regard, and it's also not in the AGLV either. So taking all those elements into account, and the fact that it's self-sufficient and ready to go, it has a lot to recommend. It has a solution to a number of the difficulties that the inquiry's been dealing with today. So thank you very much.
Thank you, Ms. Ashton.
Sir, forgive me because I was late. I didn't actually think we were going into site specifics today, not on matter 6, but you have our matter statement both on matters 1, 2 and 6 that clearly cover the merits of my client's case site. I'm not going to rehearse them again. They're before you and I don't want to waste inquiry time doing so.
Okay, anything to wrap up on Sang there from the council that we haven't already discussed quite a lot, actually?
So we have, yeah, I think we can leave it there.
Thank you. Right, I've got no further questions on this matter. Is there anything anyone wants to raise at this juncture before we adjourn and then come back for the closing session? Okay, well, thank you all for your contributions this afternoon. So this hearing session on matter 6 is closed. Take a short break till about 15:15, then come back and do the closing statement.
Thank you, sir.
Okay, the purpose of this session is to give some indication of the next steps in the process and to deal with any procedural questions that the council may have. So none of what I say should be taken as prejudging the contents of the final report, which will take into account all relevant matters and representations. So before we continue any further, if we could firstly refresh on any outstanding housekeeping matters for today in terms of action points. So I think from this morning's session, this was on the development control, amenity and heritage aspects of the plan. So there was an amendment to proposed main modification 62 to refer to special features.
So yes.
There was a grammatical changes to policy DM20 criterion C, and then the change to and or in terms of the last clause of the sentence. There was the grammatical correction to main modification 64 as well.
Yes, if they are. So I'll look behind me, but I think that's all we had.
I think that's all I had from this morning. Yeah, moving on to this afternoon. So there was the Lichfield's paper to be added to the examination library.
So just to be clear on that one, is that just put in the paper in the library? It wasn't any analysis from us.
It was just the actual source document, please. There's a Dunsfold SPD. There were the details of statutory challenge when they can be released, when they're publicly available. It'd be useful to have those there. The arithmetical corrections to the housing material and any explanatory notes that are required in the background of that. And then the note on the treatment of C2 in the housing supply, particularly where there's a replacement of C2 with C3. I think that's all I have from this afternoon. Yeah. Okay. So as I trailed in housekeeping sessions earlier today and yesterday, following the closure of this hearing, I will be reflecting on the evidence received thus far and the discussions held over the past weeks to inform my approach to the next phase of the examination, including any topics that might benefit from discussion in the light of further items of evidence which have been or are to be produced by the council. Any further hearing sessions would take place in the reserved days programme for week commencing 5th of September, and they will be preceded by a tightly focused MIQ document indicating the specific questions to be discussed. I will also consider whether any soundness or legal compliance issues relating to the matters so far discussed could be resolved by main modifications to the plan other than those that we've already discussed in the hearings. And in addition, I will reflect on whether any further work may be necessary in order to justify the plan's approach. To maintain the pace of the examination and in the interest of efficiency, I will, if necessary and where able to do so, communicate initial views in these regards ahead of any hearing sessions that may be programmed for September. The ball would then be in the council's court in terms of how it might wish to take forward any recommendations that I may make. So reflecting on and providing further directions in respect of these matters will be my immediate priority, and I aim to address them in timely post-hearings correspondence to the council, which will be published on the examination website in the usual way. So to assist me with these tasks in particular and with the efficiency of the examination more generally, it would be useful to have a consolidated list of all the main modifications discussed thus far. So do you have a view on when this might be available?
So I better check because it won't be me on this occasion. So the middle of next week's being suggested, if that's convenient.
And any preliminary view, particularly in terms of when the additional information requested in relation to sites DS01 and DS07 is likely to be available. So there was the exploration of whether a statement of common ground could be prepared on that. And then there was a site-specific material that was proposed in respect to those allocations.
So yes, if we provide, as it were, the best update we can at that point in time as well, and then take matters forward as we're able to. So it's being suggested that perhaps the end of next week might be more realistic for communications with those other parties.
So are there any procedural questions you have at this point regarding the post-hearing stage?
No, sir.
So before we close this hearing session, I'd like to invite the council to make any closing remarks they might have.
Well, sir, thank you. Just some short closing observations on behalf of the council. And I start by saying that yesterday at 3:30 p.m, I did not know if I will be able to make these closing remarks today. And it is, we would suggest, a tribute to all who have been involved in this process that we have been able to close the scheduled hearing sessions today in a timely fashion. And so this closing statement is not intended to be a summary of the issues examined during the examination, but rather, on behalf of the council, I would like to thank our examining inspector, Mr. Fort, for the careful attention he has given to part 2 of our local plan. We also thank the inspector for the further guidance and direction he has provided during the course of the examination, with a view to securing a sound plan that can emerge from the examination process. And so the council looks forward to continuing to work with you in relation to any remaining issues that require to be addressed. And as I said in opening the examination, the ultimate adoption of Local Plan Part 2 would complete this chapter in plan making for Waverley. It would do so at an opportune time with the review of Part 1 of the local plan in sight. There is a clear and compelling case for LPP2 to be in place as soon as possible in order to secure the various benefits it can provide in the short, medium and full remaining term of the local plan. It marks an important moment in the borough's progress towards delivering on its strategic aims and ambitions. The council's case has been carefully prepared and presented by a team of experienced officers who have sought to continue the council's positive and pragmatic approach to finding solutions during the hearing sessions. The detailed evidence provided on behalf of the council is we would suggest proportionate to the issues addressed by the second part of the local plan, and provides reassurance that the reasonable alternatives for the steps required to meet the overall framework set by part 1 of the plan were considered and an appropriate strategy arrived at. Part 2 will secure significant amounts of further housing to the benefit of Waverley and Woking in light of the substantial contribution Waverley continues to make to Woking's unmet housing need. It will do so by an appropriate distribution of housing and in a way that secures a range of sites. No planning decision can satisfy everyone, and that truism applies with all the greater force to a local plan, which makes substantial provision of the kind that Part 2 does, and therefore necessarily seeks to strike a balance between various important planning considerations. So Part 2 of the local plan has evolved through its various iterations with the benefit of substantial public consultation to seek to strike that balance. And through the plan-led process, the Council has positively and proactively involved its communities in a way that embraces the principles of localism. The synthesis of parts 1, 2, and the various neighbourhood plans now made or in preparation demonstrates the success of that approach locally. The adoption of part 2 of the plan will allow that approach to continue to be fostered and usher in the benefits provided by the further allocations and development management policies contained in part 2 of the plan, bringing the Council's development management into a fully framework compliant position whilst respecting important matters of local distinction. And it will allow the strategic vision and strategic policies for the borough set out in part 1 of the plan to be followed through, maintaining the high quality environment Waverley enjoys. And so, sir, the Council welcomes the opportunity to continue to progress part 2 to adoption with main modifications that are considered necessary, and it hopes to do so in the near future. And that said, all that remains is for me to thank the participants to the examination, the unflappable efficiency of our programme officer, Charlotte Glancy, and those who have assisted her, the technical staff assisting with Zoom, and Sir, you for allowing us to cover a substantial amount of ground within 2 weeks of sitting, and to do so with unfailingly good humour. And so to all those who are here, I wish you all a safe journey home, a straightforward Friday, and a more relaxing weekend. Thank you very much.
Thank you, Mr. Beglin. So finally, I'd also like to thank Charlotte Glancy for her efficient and effective work as a programme officer for the examination, and thanks also to Chris Banks, who provided support for our hearing session last Friday. I would also like to thank the Council for the timely responses to my various requests, for accommodating these sessions efficiently and effectively, both in person and virtually. It has worked seamlessly, and for the positive and proactive approach to the discussions. And I'd also like to thank all representatives who participated for their time, input, and the solution-orientated manner in which discussions have been progressed. So this, with having said that, this stage of hearings is now closed. Thank you.